With visual lordship, in this case, lordship, learned advocate general will appear on behalf of the NIA lordship. Today, I am not seeking adjournment lordship. Today, I place the factual part lordship. Factual part before your lordships, and advocate general will lordship, legal part he will argue lordship. Today morning, he is urgently went to the Chennai lordship. Otherwise, he was ready lordship.
Okay.
With lordship permit, we can place the factual part of the
Yes,
case.
let us proceed.
Lordship. Lordship.
So we had made it very clear last time. We're not going to adjourn this matter.
Lordship, that's why lordship we are.
Yes.
Today morning, we have
Yes.
decided it lordship. As per lordship's earlier direction lordship. Here lordship, the case is that lordship.
Which one are you pressing for?
Lordship, item number 1 lordship. It's a appeal filed by the National Investigation Agency lordship. Yeah. Today just only lordship I place the factual part lordship. Here lordship, the case is this lordship, the although the lordship investigating authority lordship NIA has submitted the charge sheet lordship with the definite charges of IPC and UAPA lordship against the lordship accused number 1 lordship. But the honorable court lordship declined to frame charges lordship in as per the view of the honorable court is that the material which is placed before the court is lordship not sufficient to lordship, the ingredients not fulfilled. That's why the charge was not framed lordship. Against that, we have preferred in lordship as per section 21 of the National Investigation Agency. And section 21 lordship. Page 10 lordship, section 21 appeal lordship. Notwithstanding anything contained, lordship got it?
Please read.
No. Notwithstanding anything contained.
Notwithstanding.
Notwithstanding lordship.
You are missing the with. It's very important.
Lordship.
Notwithstanding.
Notwithstanding anything
Again.
contained, notwithstanding lordship, anything contained in the court, an appeal shall lie from any judgment, sentence, or order not being an interlocutory order of a special court to the High Court of both of facts and law lordship. On the basis of that lordship, we have came before your lordship.
So it can appeal will also lie against an order of framing of charges.
Lordship. It's a final order of the Honorable Special Court lordship. So lordship, the factual part is that lordship. For that purpose, my lord may kindly take our lordship paper book.
What do you mean by an interlocutory order?
Interlocutory order lordship. It's not a final order lordship.
That we understand, but what is an interlocutory order? Appeal 21 says that it cannot lie against any interlocutory order.
It's a lordship.
Can you give an instance of an interlocutory order?
Interlocutory order lordship regarding lordship that which is not decided the law point as well as the factual part also not decided.
Here also law point has not been decided. It's
Lordship,
only a framing of charge.
here lordship, the order is the which is attain finality lordship. That wasing not framing of the charge sheet is attain finality lordship. It's a final order lordship. It cannot be treated as an interlocutory order lordship.
No, what is an interlocutory? Can you give an instance of an interlocutory order?
Interlocutory order lordship say lordship in the investigation time lordship some documents we have produced lordship, otherwise some witness has been called lordship. It was rejected by the honorable trial court lordship. Then it can be treated as a lordship interlocutory order. And other orders
against those kind of orders, appeal doesn't lie.
Appeal does not lie, lordship.
Okay.
Lordship. There are paper book to do something. Paper book. So my lord, I placed the FIR which was lordship filed by the state authority lordship, not by the state authority, one of the police inspector lordship which was filed before the Sabua PS. It is lordship. This FIR is the originating FIR where the NIA has lordship taken the investigation. It's lordship paper book 1 lordship, volume 1 lordship in page 1 to 3 lordship.
First, can we have a look at the impugned order?
Lordship.
We'll have a fair idea of what.
Lordship. Impugned order is lordship in our appeal memo itself, lordship.
In the paper book also it will be there.
Lordship, paper book also there, lordship. Page 93 in the paper book, Lordship.
It is ordered dated 22/6/21.
Lordship. Here, Lordship, ultimately in paragraph 56, Lordship, denial part is paragraph 56, Lordship.
Just a minute, please.
Paper book or page 141. Page number 141 of the paper book, Lordship.
141.
141, Lordship.
The judgment starts at 93.
93, Lordship. It starts from 93, Lordship.
Judgment dated?
Judgment dated 22/6/21, Lordship. With Lordship permit, I can place it, Lordship.
No, not everything. You can,
Lordship.
the relevant part.
Relevant part 56, Lordship, where
Paragraph 56.
paragraph 56, where Honorable Court says that, Lordship, on the basis of the materials, I also do not find a prima facie cases for the purpose of framing of charge to hold A1. A1 is, Lordship.
Accused number 1.
Accused number 1, Lordship. That will find, Lordship. A1 person criminally liable for offences of rioting, unlawful assembly, causing damages to property, causing hurt to the public officers on duty, Lordship. On that ground, Lordship, the Honorable Court negated to framing charge against the Lordship, accused number 1, Lordship. Here, Lordship, 4 accused is there, Lordship. So, Lordship may kindly 93, Lordship. 93 here it was paragraph 1 itself, Lordship.
The charge sheet was submitted under what provisions of law?
Charge sheet was submitted, Lordship. Charge sheet is, Lordship, in page 78, Lordship, page 78 and 79. My Lord, may kindly pay. It starts from page 67, Lordship. 67. Page 70 is the specific charges which was framed against the 4 accused persons, Lordship.
78.
78, Lordship.
Yes.
Lordship. Here is paragraph 17, Lordship, charges. Roman 1, Lordship, Akil Gogoi A1, he is a prosecution under sanction 120B, 143, 147, 148, 149, and so on, so Lordship. And also, Lordship, 16 of UAPA, Lordship. And another 3 persons is also there. We are not against them. Against 4.
Yes.
Now, Lordship, kindly come to the FIR, Lordship. It is in, Lordship, page 1 to 3, Lordship.
123.
No, 1.
Page 1.
Page 1, Lordship. And contents is in page 4, Lordship. Page 3, Lordship. Page 3, page 4. Page 4, Lordship.
What is the date of the FIR?
On 10/12/19, Lordship.
I think in the paper book, this date of occurrence is, I think, wrong. It should be 10.
Date of occurrence in 9, FIR was lodged on 10, Lordship.
No, it has been written 19. Just see. Page 1.
Page
1 against serial number 3.
Page 1, Lordship.
Occurrence of offense date should be 9/12, not 19/12.
9/12, Lordship.
Listen,
They have wrongly put it in here.
page 1. Mr. Borthakur, it should be 9.
9, Lordship, 9.
I think typographical error.
Even, Lordship, the contents also reflected as a 9,
No,
Lordship.
it is a typographical error. perhaps.
Typographical error.
It should be 9.
Lordship. So, Lordship, in invite, may I read, Lordship?
Occurrence 9/12/19, time 7 p.m. Please, where page number 4?
4, Lordship, 4. In inviting a reference to the subject cited above, I am to inform you that on 9/12/2019 at 7 p.m., I, along with my PS staff and Superior Additional SP Headquarters, was performing law and order duty at a Sabua town, as there was a gathering of about 6,000 citizens against the CAP 2016. The crowd was headed by the Akhil Gogoi. Sri Akhil Gogoi. They blocked the railway track as a part of the economic block. Efforts were made from district administration to remove the block, but in vain. The leaders of the crowd and some others criminally conspired against the police, and they threw stones to us. One stone hit my mouth and injuring my 2 teeth, upper jaw and upper lip grievously. Another stone hit my head, but I sustained no injuries as I was wearing helmet. Immediately, I was shifted to the Aditya Nursing Home, Dibrugarh, and given stitches and other treatments. That was an attempt murder as a part of their conspiracy against police, who that was deployed there to maintain law and order situation. I therefore paid it so and so, Lordship. It was by one Tulumoni Dora, Lordship. Then, my lord, may kindly come to page 150, Lordship. It's a sanction order issued by the authority, 150, Lordship.
Mr. Borthakur knows Tulumoni Dwara. Yes.
Lordship. Then, my lord, may kindly come to page 150, Lordship.
What are the allegation? Leader of the crowd and some others criminally conspired against police,
Lordship.
and they threw stones at us. One stone hit my mouth, injuring my 2 teeth, upper jaw. Another stone hit my head, but I sustained no injury as I was wearing helmet, and I was taken to the hospital. There was use of stones.
Lordship, above that, Lordship, my lord, may 5th line, Lordship, I kindly peruse. They blocked the railway track as a part of the economic
Blockade.
Lordship.
So what are the charges framed?
So, sir, on the basis of that, Lordship, Charge was framed by the NIA lawsuit. That part I have given lawsuit.
No. The, I mean the charge sheet, in the charge sheet.
Originally lawsuit, it is
Charge sheet, in the charge sheet.
charge sheet is page
No, we have just read the charge sheet, page 78,
lawsuit, page 17.
17. Which is the charge relating to economic blockade? Is there any charge?
17. Economic blockade regarding lawsuit that UPA section 15 is there. Except section 16 is the punishment for.
Let us see UPA. Unlawful activities prevention. UAPA.
I'm extremely sorry, lawsuit. I have not given the book, please.
No, doesn't matter. Wait. UPA.
Section 5.
No, we have. Don't worry.
দেখি বুকছে না দাদা এখন লিখে দিতো আমার দুখন আছে আমার
No, we have. Don't worry. We'll have it. You retain your book. No, I'm not look.
If lawsuit permit, I can read it, lawsuit.
No, it's okay. We have read. Which part of 15 you are?
15 lawsuit, 1 and lawsuit, Roman 2 and 3 lawsuit. Just I read it, lawsuit. Whoever does any act with intent to threaten or likely to threaten the unity, integrity, and security within the lawsuit, economic security lawsuit, or sovereignty of the India, or with the intent to strike terror, or if that part is not come lawsuit, then my lord may loss or damage to the destruction of the property. The railway property was damaged, lawsuit. That part is there, lawsuit. And lawsuit, disruption of any supplies of services essential to the life of the community of India. That blockade part, lawsuit, supply of the railway that was disrupted, lawsuit. That part is there, lawsuit. They have the peak hour, they have blocked the railway line, lawsuit. And they have also damaged the railway property, lawsuit.
Where is the allegation in the FIR? FIR need not be very elaborate, but is there
FIR
any,
did not elaborate, otherwise also.
is there any indication that railway property was damaged in the
Lawsuit,
FIR?
FIR lawsuit, that part it is not specifically mentioned, lawsuit. Otherwise, lawsuit, the report is there, everything is there. And the railway, that blockade part is there, lawsuit, in the FIR lawsuit.
Okay.
They blocked the railway track as a part of the economic block. Efforts were to made by the district administration to remove the block, but that is in vain, lawsuit.
Okay.
Lawsuit. Then my lord may kindly come to lawsuit. Page 150, lawsuit.
One
150, lawsuit.
What is there?
It's a order issued by the Ministry of Home Affairs, lawsuit, regarding the giving the permission to the National Investigating Agency, lawsuit. Lawsuit. It's a given under the subsection 5 of section 6 of the NI Act, lawsuit. Legally. Lawsuit permit, I can read it, lawsuit.
What are the schedule offense?
This word. Also page 12, my lord, may kindly come to page 12 also. Schedule is there also. Page 12 also.
Investigation, security. Yeah. You know, security. National investigation applies. How about what the other called UAPA.
Schedule 2 is there also. I can read it also.
No, okay, you can read. What is it? Yes,
Okay.
please read.
That schedule offense part also.
No, we have just seen.
Order.
We have seen for which schedule is connected?
It's lordship 2, serial number 2 lordship. The schedule, the Unlawful Activities Prevention Act.
UAPA.
UAPA lordship. UAPA. Then my lord may kindly come to page 150 lordship. Whereas the central government has received information regarding registration of FIR related non so and so in Dibrugarh, Assam under section so and so lordship. The complainant of SI Tulumoni Dora relating to economic blockade still on the railway track and routes at Sabua town on 9/12/2019 by protesters headed by Akhil Gogoi against Cape Citizenship Amendment Bill lordship. And whereas during subsequent investigation, section 153A and 153B of the Indian Penal Code and section 15(1) small a of the Unlawful Activities Prevention Act 1967 were added by the local police lordship. And whereas one Sub-Inspector Tulumoni Duras targeted and attacked by the protesters by throwing stones, as a result of which he sustains grievous injuries and a loss to teeth and permanently and severe injuries on his mouth lordship. It should be hard lordship. And whereas the protesters against CAB in Assam were organized the intention to disturb the unity and integrity of India, and whereas the central government is of the opinion that schedule offense in terms of the NIA Act 2008 has been committed, and having regard to the gravity of the offense, it is required to be investigated by the National Investigating Agency in accordance with the National Investigation Agency Act 2008 lordship. Now, therefore, in exercise of the powers conferred under subsection 5 of section 6, read with section 8 of the National Investigating Agencies Act 2008, the central government hereby directs the National Investigating Agency to take up the investigation of the aforesaid cases. Then my lord may kindly come to page 5 paper book, lordship.
This unlawful activities was the provisions of UAPA was added later.
Later, it was later added, lordship, later added.
The FIR was lodged on 10/12/19.
Lordship.
And these additions were done when?
Addition were done, lordship. Page 161, lordship. 161.
161.
161, lordship. It is on lordship 23rd March 2020, lordship. Hmm? Well, one 168.
Where is the order of the court allowing the prayer?
It is 23. 23. Prayer was allowed on 23rd of March,
No,
Lordship.
no, it was not allowed. Prayer would be considered on production of the accused person.
Lordship.
When was it allowed? See the last line. See the last line, Mr. Gogoi.
Lordship, I have said.
Prayer will be considered on production of accused person.
Lordship.
So on 23rd March 2020,
Lordship.
it was not added. When was it added?
Lordship, then my lord may kindly come to page 165, Lordship. Is
allowed.
directly come to page 166, Lordship,
163rd third paragraph.
third paragraph, Lordship. The pair of the IO for addition of.
This is on 1-4.
This is on 1-4, Lordship. 1-4.
Okay.
Then my lord may kindly come to
There is
page.
an observation at 166 paragraph 2.
Lordship.
Further CD reveals ample materials against the accused for commission
Lordship.
of offense under the UAPA.
Lordship.
Okay.
Lordship. Then my lord may kindly come to page 5, Lordship. Page 5. वो वाला कितना पैसा था वो वाला सेंट्रल यूनिवर्सिटी वाला पेश ठीक है See, after MSA order on 4th April 2020,
You want us to come to page 5?
Lossi. It is Lossi after the MSA order, Lossi. MSA order was Lossi 150, Lossi. That order was on 4th April 2020, Lossi. After that, Lossi, the 9/4/2020, Lossi, the NIA case was registered, Lossi. FIR. It is on 9/4/2020, Lossi.
There is a requirement to register a fresh case.
Lossi, that it is a not registered, it is renumbered. It was renumbered. Renumbered as Lossi, FIR now RC 012020, Lossi.
Yes.
Lossi. Yeah, FIR number is lordship, date and section is lordship, so and so lordship, suspected offense lordship. The central government has received information regarding registration of a case of FIR nong so and so at PS Sabua Dibugor Assam under section so and so lordship on the complaint of the SI Tulumoni Dua relating to the economic blockade staged on the railway track and roads at Sabua town on 9/12/2019 by protesters headed by Akhil Goi against Cape Citizenship Amendment Bill lordship. During subsequent investigation, section 153A and 153B of the Indian Penal Code and section 15(1) small a of the Unlawful Activities Prevention Act 1967 were added by the local police lordship. During the protest, one so and so was targeted and attacked by the protesters by throwing stones, as a result of which he sustained grievous injuries and lost to teeth permanently and severe injuries on his mouth. The protests against Cape in Assam were organized with intention to disturb the unity and integrity of India lordship. After that, my lord may kindly come to lordship, page 151, this sanction part lordship.
Hmm.
25th June 2020 lordship.
This is the sanction order.
Lord, it's a sanction order lordship. Up to paragraph 6, facts is there lordship. It is, I am not reiterating it.
Yes.
Paragraph 7 lordship. It's in page 152 lordship, 152 lordship.
Hmm.
And now therefore, the central government, after carefully examining the materials placed on record and on the recommendation of the authorities, satisfied that a prima facie case is made out against the accused persons under the relevant sections of law, and hereby accord sanction for prosecution under section 45(1) of the Unlawful Activities Act 1967 lordship for prosecuting following accused person in a crime number lordship. It is the NIA case number, taking cognizance of the said offences by a court of competent jurisdiction. A1 is the Akhil Gogoi lordship, against whom lordship the sections of law for which sanction for prosecution is accorded lordship. It is section 16 of the Unlawful Activities Prevention Act lordship 1967 lordship. And other persons also there, Jagjit Guhai, Bhaskorjit Pukon, and lordship Bhupen Gogoi lordship.
Yes.
Lordship. On the basis of that lordship, the NIA has lordship investigated the case lordship. Then lordship, we have submitted the charge sheet, and charge sheet is lordship in page, starts from lordship page 67 lordship.
Is there a date?
Lordship,
Date of the charge sheet?
date of the charge sheet lordship 67. 26/6/2020 lordship, and charge sheet number is lordship 06/2020 lordship. It is in page 67 lordship.
6/7.
Page 67 lordship. Which are paragraph, sir? 15. So lordship, brief fact, I just reiterated 2-3 paragraphs lordship regarding submission of charge sheet lordship. It's, my lord may kindly come to page 70 lordship. .1 lordship. On
Yes.
On 10/12/2019, a written complaint was lodged by Sri Tulumoni Dura, SI Sabua PS Dibrugarh Assam, in which it was alleged that on 9/12/2019 at 7 p.m., while SI Tulumoni Dura, SI along with
Not SI,
Sri Tulumoni Dura, SI along with other police staff and additional SP headquarters were performing law and order duty at Sabua town, There was a gathering of about 6,000 people against the camp led by accused Akil Gogoi. They blocked the railway track as part of the economic blockade. District administration of Dibrugarh district tried to remove the blockade, but in vain. The leaders of the crowd and other people conspired and threw stones on the police personnel. Due to the stone splitting, SI Tulumoni Dora of Sabua PS was seriously injured, sustaining injury to his teeth and upper jaw, and it was further alleged that the mob led by the accused attempted to murder the police personnel deployed on duty on that day. Then 15-2 lawsuit. On the basis of the complaint lodged by the SI Tulumoni Dwara, an FIR was registered at Sabua Police Station, Dibrugarh District Dibrugarh, Assam, Bhait number 289 of 2019, dated 10-12-2019 lawsuit, under section lawsuit 120B and so lawsuit, and cases were endorsed to Sri Khogans Loskar SI Sabua PS for investigation. During investigation, sections 153 and 153B of the IPC and section 51 small a and 16 of the UAPA Act were added, and the case was endorsed to Sri Kulapradip Bhattacharya ASP, Deputy Superintendent, Namrup lawsuit. 15th lawsuit. Subsequently, in compliance of the Ministry of Home Affairs, Government of India's order number so dated 442020 lawsuit, the FIR number so dated 942020 was re-registered lawsuit. Page 71 lawsuit.
Yes.
Re-registered at the NIA branch office, Gauhati, under section so lawsuit, arising out of FIR number 289 of 2019, dated 10-12-2019, registered at Sabua Police Station, District Dibrugarh, Assam, to investigate disruption of supplies by economic blockade staged at the railway track and national highway at Sabua town on 9-12-2019 by protesters led by Akil Gogoi, and attempted to murder the government functionaries on duty by throwing stones lawsuit. 15-4 lawsuit. The FIR was submitted before the Honorable NIA Special Court, Gauhati on 9-4-2020, and investigation was taken up by the NIA branch office, Gauhati lawsuit. Then 15-5 lawsuit. During investigation, 4 accused persons, namely Akil Gogoi A1, Jagjit Gohai A2, Bhaskarjit Phukon, Elias Sorgaditya Phukon A3 lawsuit, and Bhupen Gogoi lawsuit A4 were arrested on 014-2020 and 19-2020, 11-5-2020, and lawsuit 11-5, and respectively. And lawsuit A1, A3, and A4 are presently in the at that time lawsuit, they are in the judicial custody. A2 is on the bail lawsuit at the relevant point of time lawsuit. Facts disclosed during investigation lawsuit. 16-1. During investigation, it was revealed that Lok Sabha was salted a debate to pass cap on 9-12-2019, accused A1 along with A2 and other accused conspired to commit terrorist act and create wide-scale unrest in various parts of Assam since first week of December 2019. In pursuance to this conspiracy, the accused A1, A2, A3, A4 and others had planned to disrupt supplies of essentials for life of community in India, damages properties, and installing fear in a section of people of India at Dibrugarh. Subsequently, as per the criminal conspiracy, A1 traveled from Gauhati on 8-12-2019 and reached Dibrugarh in the morning of 9-12-2019. Investigation revealed that in order to execute to their conspiracy, accused persons led by A1 and other accused persons mobilized a mob of around 6,000 person lordships. Investigations further established that the accused persons led by A1 provoked and led the mob in violation of section 144 CRPC imposes in Sabua PS area by delivering provocative speech and to lead to commission of terrorist act in the grave of protest lordship. Then my lord may kindly come to paragraph 16-2 lordship. During investigation, it is revealed that accused A1, A2, A3, and A4 and others conspired to cause disruption of supplies by way of blocking the national highway and railways. In pursuance in this conspiracy, a program was organized at Sabua on 9-12-2019, in which accused A1, A2, A3, and A4 and others participated. A1 delivered aggressive and provocative speeches, and the speech has been taken on record in the instant case lawsuit. The accused person incited the mob in violation of Section 144 CRPC imposed in Sabua on 9/12/2019, resulting in disruption of supplies essential for life of community in India lawsuit. The accused persons led to mob with weapons and thus caused damages and destructions of public and private property, railway station, obstructions of duty of government officials, and attempt to kill government functionaries on duty by show of criminal force lawsuit. Then 16th lawsuit. The mob was provoked by accused A1 and other accused, which led to the act of damage and destruction of property by using inflammable substance, stopping the trains, thus disrupting supplies essentials for life of community in India, obstructing the railway employees on duty from discharging their duties. The mobs led by the accused also attempted to kill government functionaries, causing grievous injuries to the OC Sabua PS. These activities of disrupting supplies, damages, and destruction of properties, attempting to kill government functionaries by show of force, has led to striking of fear in certain sections of people of area. Then 16.4 OC. The conversations of A1, A2, A1 and A2 as figured in lawful interceptions revealed in conspiracy of the Terrorist Act as defined in Section 15(1) small a, Roman 2 and Roman 3, and small b, and subsequent to presence of the accused person at spot in committing that act, which created fear of a section of people of the area, has been established during investigation lawsuit. 16.5. Statements of witnesses, video footage, identification of the accused taken on record during investigation clearly established that mob was provoked, leading to attack to kill government functionaries by show of criminal force, resulting in obstruction of their duties and grievous injuries to government officials on duty. Damages or loss of government and public/private property, disruption of rail service at Sabua railway station, and disruption of the vehicle movement of NS 37 on 9/12/2019, thus disrupting supplies essentials for life of community in India and causing fear in a section of people of the area lawsuit. Then 16.6 lawsuit. During investigation, scrutiny of videos seized from Cyber Cell Sabua Dibrugarh, along with 65B certificates established the terrorist act of the destruction of property, attempting to kill government servant on duty by use of criminal force, which instill fear in a section of the people of area lawsuit. That lawsuit, that video footage file is number is their lawsuit, and content is also their lawsuit. And file serial number 1 lawsuit, the content persons armed with deadly weapon destroyed the camera lawsuit. Then 2 lawsuit, speech delivered by the accused A1 lawsuit. Then 3 mob damaging one white color vehicle lawsuit. Then 4 lawsuit, mob damaging a vehicle. 5 lawsuit, mob damaging a vehicle. 6 provocative speech by lawsuit A1. 7 speech delivered by accused A1 lawsuit. 8 lawsuit is a WhatsApp video lawsuit, police officer with grievous facial injury lawsuit. Then 7 lawsuit. During the investigation, scrutiny of videos seized from the Proceeding Time News channel, which have been taken on record in the instant case, establishes the ingredients of terrorist act of damaging property, disrupting supplies essential for maintenance of life of community in India, attempting to kill government servant by show of criminal force, and creating fear in a section of people area lawsuit. Now, serial number 1 is lawsuit. In this clip, a police officer has grievous injury. 2 lawsuit. In this clip, protesters were damaging the property. It is Mahindra vehicle lawsuit. 3 lawsuit. In the clip, A1 is welcoming the protesters and saying that the fire would be spread. 4 lawsuit. In this clip, mob has used inflammable substance to burn tires of vehicles on road lawsuit. 5. In this clip, the mob is gathering via motorcycle rally lawsuit. Then 6 lawsuit. In this clip, protesters were blocking route by big stones and burn tires on the road, thus disrupting the supplies essential for life in community in India using inflammable substance lordship. Then 7 lordship. In this clip, mob is gathering in pursuance to the conspiracy of terrorist act of damaging properties, attempting to kill government functions on duty lordship. 16.8 lordship. The CDR analysis of mobile number used by accused establishes that A1, A2, A3, and A4 were in close telephonic coordination with each other during the relevant period in pursuance of the conspiracy, and all of the 4 accused persons were present in Sabua on 9th December 2019. Their connectivity chart is under lordship. That chart is given lordship. Then 16.9 lordship. During investigation, incriminating documents, materials, objects have been seized. Further statements of witnesses acquainted with the incident of stone plating and other agitation activities of the mob were recorded under Section 161 CRPC. The evidence clearly established the fact that accused persons, in pursuance of the conspiracy to commit terrorist act, have damaged property, disrupt supplies essentials for life of community in India, and attempted to kill government functionary on duty, and this act of accused person has led to the create fear in a section of people of the area lordship. 16.10 lordship. Medical reports related with regard to the injury of the SI so and so were collected along with statement of the treating doctor, which clearly establishes the grievous injury sustained by the government functionaries in pursuance of the conspiracy of the accused persons to kill government functionary by show of criminal force lordship. 1611. During investigation, relevant records of the railway have been seized on production, which reveals that various trains were diverted, as a result of which conspiracy or disrupting supplies of essential for life of community in India on 9/12/2019 lordship. Then lordship 1612. During investigation, motor vehicle inspections, reports of damaged white Mohendo Bolero vehicle number so and so, along with statements of the witnesses recorded, clearly established the damage to property in pursuance of the terrorist act by the accused person. 16.13 lordship. After going through the oral documentary and technical evidence brought on record during the investigation, it is clearly established that accused A1, A2, A3, and A4 and others conspired to cause blockade by way of the blocking the national highway and railways, thus disrupting supplies essential for life of the community in India. In pursuance to this conspiracy, a program was organized at Then, my lord,
May I quickly leave for a moment? Okay, go.
then my lord may kindly come to the rule of the A1 lawsuit. It is in page 75 lawsuit, 16.14 lawsuit. Investigation with respect to the rule of A1 lawsuit. Roman 1. A1 delivered provocative speeches at the spot in Sabua, which has caused disruption of public peace and damage and destruction of the public and private properties and disruption of services of essential for life for community of India and created fear in a section of people in India who is in a terrorist act as per section 15.1 small a, Roman 2 and Roman 3 and small b lawsuit. Then lawsuit Roman 2 lawsuit. A1 led a mob of violation of section 144 of CRPC imposed at Sabua on 9/12/2019. A1 led the mob to cause damage to public/private properties with intent to strike fear in a section of people in India lawsuit. Then lawsuit 3, A1 led to mob armed with deadly weapon and attempted to cause death of public functionary by show of criminal force and thus caused grievous injuries to the government servant on duty lawsuit. Then 4 lawsuit, the mob led by A1 was planning to set fire of a house of a Bengali dominated area, Amravati colony lawsuit, and this establishes the fact that A1 led a mob with intent to strike terror in a section of people of India. The statement of witnesses reveals that the terrorist act of A1 in pursuance of a conspiracy led to fear in a section of people in the area law. Then lawsuit 5, the oral evidence, documents, materials, subject, and technical evidence collected during the course of investigations are established the prima facie case against the accused for prosecution of the offences lawsuit. Yes, because lawsuit section 16 of the UPA was lawsuit added lawsuit. Section 55, section 15 will come. Section 15 define lawsuit terrorist act lawsuit. The ingredients which was here lawsuit, it is the ingredients of the terrorist act lawsuit. Then lawsuit, the charges, next page 78 lawsuit. Other persons also there. B lawsuit. 76 B lawsuit. Investigation with respect to the rule of Jagjit Guhai lawsuit. A2. A2 in association with A1 cause and coordinate to be caused the economic block by causing National Highway 37 and railway lines blockade at Sabua on 9/12/2019. A2 does his association with A1 led to blocking
Where
of
are you reading?
page 76 B.
76. Yeah. Jagjit is also a party before us, no?
Party not before us, otherwise if the for A1 part he is also
Connected.
loss. That's why. So let's say Roman 1. A2 in association with A1 caused and conducted to coordinate to be a cause the economic blockade by causing NS 37 and railway lines blockade at Sabua on 9/12/2019. A2 does in association with A1 led to blocking of supplies of essentials for life of community in India, which is a terrorist act as per section 15.1 small a and 1.3 lawsuit. A2 in association with A1 and other accused led a mob in violation of section 144 CRPC imposed at Sabua on 9/12/2019. A2 in association with A1 led the mob to cause damage to public and private properties with intent to strike fear in a section of people in India lawsuit. 3. A2 in association with A1 lead to the mob armed with weapons and attempt to cause death of public functionary by show criminal force and thus cause grievous injury to the government servant on duty with intent to strike fear in a section of people. Lordship. 4. The
What is
mob
this? We wanted to ask you, what is this armed with weapons?
that part Lordship, stone and other part is
Stones.
Stone in the FIR reflect stones part. Other part Lordship,
No, in the investigation, did you recover any arm?
in invest arms not videos
Some videographs are.
Videos showed what? Weapons?
Video showing the weapons by accused person.
What kind of weapons?
Some long, big, this one, they are showing to mob.
probably lathi and other things is there also.
Okay.
Lordship. The mob led by A1 in association with A2 has planning to set fire on the houses of a Bengali dominated area, Amravati colony. This establishes the fact that A2 in association with A1 led a mob.
How do you substantiate this? What
The
material do you
evidence
have?
is there, statement is there.
Statement.
Statements are there also. I will come on later on statements also. Statements is there also. The statements of witnesses reveal that the terrorist act of A2 in pursuance to the
Just a
conspiracy.
clarification. You have also relied upon a number of videograph,
Lordship,
WhatsApp
Lordship,
videos.
Lordship.
The learned trial court had, those were exhibited before the learned trial
Lordship,
court.
it is there. Even Sasit also, Lordship, it was reflected, Lordship, that part.
No, not on the charge sheet part. The satisfaction of the learned trial court to frame or not to frame charge.
Lordship.
Did the trial court had the scope and opportunity
All
to,
the records are placed, Lordship. Records are placed.
the videographs?
Videographs, all are placed, Lordship. All are placed.
So, if required, we are the appellate court, we might also need to request.
Lordship, you can place it, Lordship.
You have to have those ready handy.
Lordship, you can place it. You can.
Yes.
Lordship. Then Lordship, the C, investigation with respect to the rule of Lordship, Bhaskarjit Pukon, alias Sorgaditya Pukon Lordship, A3. A3 in association with A1 cause and coordinate to cause the economic blockade by using causing an NS37 and railway line blockade at Sabua on 9/12/2019. A3 does in association with A1 led to blocking of supplies of essentials for life of community in India, which is a terrorist act as per section 15(1) small a and 1(3) Lordship. Then Lordship 2. A3 in association with A1 and other accused led a mob in violation of section 144 CRPC imposed at Sabua on 9/12/2019. A3 in association with A1 led to the mob caused damage to the public and private property. Almost Lordship contents are similar Lordship. Contents are all are similar Lordship. So Lordship suggests page 78.
Just
148 and 144. Right. Then what is charges? So
Yes.
charges in lordship, page 78. Lordship has already gone through it, lordship. And except lordship, the eighth lordship. Eighth Bhaskarjit Pukon, my lord may kindly page 78 lordship.
78.
Page 78, eighth lordship. All the three A1, A2, and A4 lordship, they are discharged under all sections by the trial court lordship, learned trial court lordship. And in respect of lordship, A3 lordship, two sections are lordship. It is section lordship 144 and 148. Charge were framed under two sections lordship. Other section they have discharged. It is in discernible from page 148 lordship.
148.
148 lordship. 148. It final order starts from 147 lordship. My lord may kindly 147 paragraph 76 lordship.
Yes.
So here lordship, paragraph 76 lordship. Accordingly, in view of the aforesaid findings, three of the accused person, namely A1, A2, and A4 lordship, are hereby discharged lordship. The bail one so and so lordship. Then my lord may kindly come to next page lordship. Page 77 lordship. Paragraph 77. The charges are framed against the accused A3 lordship.
Why the only if page 76, para 76, A1, A2, and A4 discharged.
Discharged lordship.
Bail bonds of A1, A2, A4 stand discharged.
Lordship.
Accused A4 sat at liberty forthwith.
Lordship. If not required, lordship.
That means A1 and A2 are on bail.
Bail.
On bail.
A1, A2,
And A4 was in custody.
Lordship.
So it has been
Lordship.
directed that he should be
Lordship.
set at liberty forthwith.
Lordship. Then my lord may kindly come to page, next page lordship, 77 lordship. So paragraph 77 lordship. However, charges are framed against accused A3 under section 144 and 148 of IPC lordship. The said charges are read over and explained to accused A3, to which he denies and claimed to be tried lordship. Then lordship 78. Now section 144/148 IPC are magistrate triable and they are also not scheduled offense under the NIA Act. Therefore, the court will not have jurisdiction to continue the case against A3, and the remaining proceedings with regard to the A3 will have to be continued in the Judicial Magistrate Court in the district Dibrugarh lordship. Although lordship, the activities which was done by all the four accused persons are exactly similar putting it. Exactly same was done with the conspiracy with the A1 lordship, they have done lordship. But lordship, in all other sections, they are discharged lordship except A3 lordship, A3 two section, rioting and unlawful, that two sections were lordship. That two sections are lordship given for trial by magistrate lordship. In respect of the A3, that's I indicate lordship. So lordship, now I come to the lordship evidence part. If lordship permit lordship, I can read the evidence part lordship. Page 8 lordship.
Yes, sir.
Except That part we also know. Don't know. What do you mean? No, this is super hard. Look at me. Look at this file. Details on the it's important. 17. Yeah. 44 we have done. Into 17. Or 44 we have done.
Mr. Gogoi,
Lost.
just a clarification.
Lost.
See, you are aggrieved by the order of discharge.
Lost.
And so far as one of the accused is concerned,
Lost.
learned trial court has held
Lost.
that prima facie materials are found so far as certain offense under the IPC are there.
Lost.
Are you sticking to a claim that the offense under the NI is also to be substance materials for framing charge to be a trial under the NI is also there, or are you contending that if we find materials that offenses under the IPC, earlier IPC is there,
Lost.
it can proceed before a competent court? What is your case?
Lost. Our case is that the offense under which is committed is as per NI. That's why we are here.
No, are you sticking to your to a stand that it has to be an NI offense, an offense under the schedule of the NI, and therefore the NI court has to try it?
Lost.
Or are you only on the aspect that there are other materials also so as to frame charges,
Lost.
and therefore total an order of total discharge is not sustainable?
That part is there. Lost. That is there. Lost.
Because two parts are there.
Two parts.
See, you may succeed in the entire attempt. In one entire attempt, yes. There are also materials. The entire materials are there, even for proceeding under the NI Act.
Lost.
That is your, and you may partly succeed.
Lost.
That NI you fail, but you succeed on the other parts.
To both. Lost.
It may not be a case of total discharge.
Lost. This is our case. Lost. So, Lordship.
No, because we think that though it would be an endeavor to make out a case that since charges were framed, I mean, the charge sheet was filed under scheduled offense of NI. So the aspect of not framing charge is not sustainable in law. That would be your first attempt. This order should go and charges should be framed even under the NI. The second is that if you fail in there, you may contend that other materials for framing charges under IPC are there. So this order otherwise is also not sustainable. Yes, my brother has also put a question. What is the status of the trial of the A3 before the magistrate?
A3 part, A3 not here, all records are here.
Records are here. Okay, it's not proceeded.
Lost.
No, record could have been, scan copy could have been made. Scan copy could have been made because it has to be segregated.
Lost. He also one of the party here also in our cases also. In appeal also.
Okay.
In all the four are there also.
How many appeals are there?
No, one appeal.
Oh, you have all the four accused are parties. Okay. You are also aggrieved by that part by which he has been absolved of the liability under the NI Act.
Lost.
Yes.
Here Lordship, page 8 Lordship, it is a protected witness Lordship under section 17 of NI Act and section 14 of the 44 of the UPA Lordship. Page 8 Lordship. Paper book Lordship, page 8 Lordship. Lordship. Statement of protected witness, Lordship. A. Recorded under so and so, Lordship. On being asked, I have to state that on 9/12/2019, so and so founder member of KMSS called me and asked why me and my supporter are silent. Further, he provoked and told me to do something fairy, and I replied him to join. After some time, I joined him, and around 1800 hours, Lucy, we reached at Sabual, and there was a large gathering. An atmosphere of meeting place was very noisy, and after reaching so and so, the mob of crowd got more surge, Lucy. However, so and so addressed the meeting. During this speech, so and so provoked the people and asked them to oppose the government, issuing
Using-
using any means, whether they had to do anything for it. Due to his provocation, some people from the crowd started placing stones on security officials. One of those stones hit on the mouth of so and so, OC of Sabua PS. He got grievously injured, and two of his teeth were broken and was bleeding profusely. And even then, the crowd did not stop and overturn and damage the Bolero vehicle on the road, probably on government duty. Even after the turning the crowd violent, so and so did not denounce to same and or did not did, did anything to stop them, Lucy. Today I have been shown transcript of my telephonic conversation with so and so dated so and so. In this regard, I state that it is my telephonic conversation with so and all the contents which were mentioned in these conversations are correct, Lucy. He is a protected witness under section 17 of the NI Act and 44 of the UPA Act, Lucy.
Yes.
Then, Lucy, the statement of the Tulumuni Dora, Lucy. Next page, Lucy. Statement of Tulumuni Dora, Lucy. I am as above stated that I was born on so and so, Lucy. Third paragraph, Lucy. Lucy may start from fourth paragraph, Lucy. On being asked, further state that on 9/12/2019, when I, along with my PS staff and additional SP HQ, was performing law and order duty at Sabua town, as there was a gathering of about 6,000 people headed and addressed by Mr. So-and-so, leader of the KMSS, and they blocked the railway track as part of the economic blockade. I also saw that they had damaged a gypsy vehicle and Indo-Tibetan Border Police ITBP, which was passing by National Highway going to the Arunachal Pradesh, Lordship. And during the meeting, meeting period, I got information from Devarki Setia that some protesters were planning to burn down the houses of a Bengali dominated Amaravati colony area. I immediately informed Sri Subhash Chandra Kasari, Circle Inspector Sabua, regarding the situation and further requested him to deploy police party to reserve police battalion in the area, Lordship. We went forward to stop them and tried to remove the blockade, but it was in vain, and as they were provoked by so-and-so, the leader of the crowd, Mr. So-and-so, and his associates criminally conspired against police and government officials and threw stones to us. One of the stones hit my mouth, injuries my two teeth, and where one teeth completely broken, and also sustained grievous injury in my upper jaw and upper lip. Another stone hit my head, but I was wearing a helmet. Immediately went to the model hospital Sabua. Then doctors referred me to Aditya Nursing Home for better treatment, Dibrugarh, and doctors gave stitches and other treatment. One of my teeth had to be completely removed, and another one is about to be removed. It was an attempt to murder as a part of their conspiracy against police who are deployed there on maintain law and order. At the same time, the associates of so-and-so also damaged a white Bolero vehicle on the duty under CRPF, and they had turned the vehicle over on its side on the road Mr. So-and-so and his associates by way of their action obstruct the police and government official from performing their duties as well, Lordship. The gathering of people was still being addressed by so-and-so, leader of KMSS, as I got injured and was being shifted away from the site, Lordship. The following persons were present among gatherings, Lordship. The persons' name were reflected, Lordship. During the course of investigation, it revealed that two persons, namely so-and-so and so-and-so, were also present along with other protesters, Lordship. In this connection, FIR number so-and-so under section so-and-so was lost at Sabua PS, Lordship. Then my lord may kindly come to statement of Lordship Khogen Lohkor, Lordship. It is next page, Lordship. I am as above mentioned on being asked, I state that I am working as second OC at Sabua PS, Lordship. Page 12, Lordship.
Yes.
On being asked, I further state that on dated 9/12/2019, one meeting was held at near Sabua railway station regarding protest against cap/car bill and a law and order duty by OC Sabua PS SI Tulumoni Dora and police staff on Sri Akhil Gogoi headed to the said meeting where he was giving speeches against the government. Some violent people came to NS 37 way and planted stones at vehicle and damaged several vehicles. As a result, OC Sabua PS sustained grievous injuries. And on 10/12/2019, SI so-and-so lodged a FIR against so-and-so. In this regard, one case was registered by FIR number so-and-so under section so-and-so, Lordship, and endorsed me to the case for investigation. In connection of the case, I visited the place of occurrence, recorded the statement of complainant and witnesses and in the CD, Lordship. I also sent the complainant for medical treatment and also collected the report of the same. In connection of the case, I also seized one stone, duty register, and one pen drive as per seizure list. On the basis of sufficient evidence and witnesses, in connection with the case, I had arrested accused so-and-so, Lordship, so-and-so, and were searched but could not, and also in respect of accused number Sri Bhupen Gogoi and Sanjoy Dhingia and Sukhaditya Fukon were searched but could not be arrested in connection with the case. Later, one pair was submitted before the Honorable Court for adding section 153A and 153B of IPC, read with section 16A of the UAPA, Lordship, and accordingly added. And later, on Bhait SP's office memo number so-and-so, the said case diary was handed over to the Deputy Superintendent of Police, Lordship, Kulapradip Bhattacharya, Lordship. On 28/5/2020, NIA official Sri Prem Krishan Kakoti, Inspector, and Sri Devendra Kumar Mishra, Inspector, attended Sabua PS, and on their requisition, I produced one seized piece of stone in connection with the above incident. Original copy of the medical report of Sri Tulumoni Dora, SI/OC of the Sabua PS, certified copy of the duty roster page, and one certified extract copy of the Sabua PS GD number so-and-so, Lordship, containing one pages of which were seized by NIA seizing officer in presence of two witnesses by preparing production cum seizure memo, Lordship. Then my lord may kindly come to next page, Lordship. Say statements of Lordship Kulapradip Bhattacharya, Lordship. I am as above state that I joined Assam Police on so-and-so as a Deputy Superintendent Police, Lordship. I am posted as Deputy Superintendent Namrup, Lordship, since 28/12/2018. I am present IO of the case number so-and-so, Lordship. The investigation of the case was taken over from Sri Khogen Lohkor SI Sabua Police Station on 2/4/2020, Lordship, and continuing the investigation. During investigation on 1/4/2020, I, along with Nitul Sunwal, CI, and Khogen Lohkor SI and police staff went to Sibsagar jail to arrest Akhil Gogoi in case number so-and-so, Lordship. Further state that I have bought all the record and exhibits relating to the case for further handing over CIO of the NIA, Sri DR Singh, Additional SP. Further, Now further investigation will be done by the NIA branch office Gauhati Lordship. Then Lordship PW5. Sanjeev Setia Lordship. My name and address are mentioned above. I am serving as a UBC Lordship at Sabua PS. So and so, the leader of the Krikok Mukti Sangam organization, a rail blockade at Sabua railway station to protest against the cap, and approximately 6,000 to 7,000 people gathered there, Lordship. We, along with OC staff and Honorable SP headquarters Dibrugarh, were on law and order duty at that place, Lordship. When the people present at the meeting got agitated and prevented the movement of vehicle along National Highway 37, Lordship, we, along with OC and the district administration, tried to clear the road. Around 7 p.m., some agitated people led by so-and-so started throwing stones to the police party. Though we were not injured, OC was struck by stone on his face, Lordship, as a result of which two of his teeth got broken and he sustained a cut on his upper lip. Immediately, I, along with the staff member, took the OC away from the place of occurrence and then brought to him to the PS, Lordship. Then, and PW6 also similar, Lordship. Then PW7 also similar. And PW8, Nabajoti Setia, Lordship. I read it, Lordship. My name and address are mentioned above. I am engaged as a driver at Sabua PS. On so and so, I transported the OC and police staff by a vehicle from the police station to Sabua railway station, where a rail blockade was organized by Akil Gogoi to protest against the cap for law and order duty, Lordship. Additional SP SQ was also present there. Around 7 to 8,000, 7/8,000 people were present at the meeting. The people present at the meeting became agitated and blocked National Highway 37, thereby preventing the movement of vehicle along the route. When we, along with the district administration and the OC, tried to clear the route around 7 p.m. Lordship, some agitated people led by the Okilugo started throwing stone to us. Though we were not injured, the OC was struck by stone on his face, as a result of which two of his teeth got broken and he sustained the cut of his lips, Lordship. We immediately so and so, Lordship. Then, Lordship, PW9. PW9 also same, Lordship. 10 also, Lordship. Exactly similar version, Lordship. 10, 11 also same, Lordship. Then, my lord, PW12, Lordship. PW12, Lordship. Statement of page 23, Lordship. Statement of witnesses of Sri Subhas Kosari, Lordship. My name and address as mentioned above are true. I am on duty at the office of the CI Sabua in the afternoon 9/12/2019 upon receiving information from the OC Sabua PS that CAP protesters led by so-and-so, the Krikok Mukti Sangam Committee leader, were holding a rally near Sabua Sariali, close to the railway station, to carry out a rail blockade program. I, accompanied by my bodyguard staff, arrived at the location of the rally. My staff and I were ensuring that at the time of the rally, no persons could cause route blockade to create a chaotic situation. People of Sabua police station and a section of CRPF were also carrying out their duty there. When the rally was going on, I noticed that about 3,000 to 4,000 people had gathered there. In the initial stage, I heard the leaders, orators of different organizations asking the gathering to continue the movement by maintaining peace and tranquility. But around 6 p.m., Lordship, Sri Akhil Gogoi, the leader of the Krikok Mukti Sangam Committee, created a tense situation at the place of the rally by delivering a long speech against CAP, criticizing the directives of the present so-and-so government and thus instigating the people present there to execute rail blockade program as a part of the economic blockade, thereby provoking the people present there to build a violent movement. Immediately after that, some people from the rally tried to stop the vehicle playing on the highway by placing stones, thereby damaging them. And when we, the police personnel, tried to resist them, the agitated public attacked the police also, as a result of which OC sustained grievous injuries, including the breaking of two of his teeth. Provocative speech of Sri Sovenso, leader of the Kikhok Mukti Sangam Committee against the government, is the main reasons for occurrence of the incident, Lordship. Then PW 13, Lordship. 13 also similar line, Lordship. 14 also similar line, Lordship. Then my lord may 15. Witness on Robin Gogoi, Lordship. My name and address as mentioned above are true. I am the driver of the vehicle of the circle officer of the Sabuar Revenue Circle. My mobile phone number is so and so. On the evening of 9/12/2019, I drove SDC sir along with an accompanying police party. When I parked the vehicle by the roadside near Sabuar railway station, I heard KMS leader so and so delivering a provocative speech. In his speech, I heard she so and so address the protesters to involve in the movement against the CAP and instigating them against the government and arguing them to build a violent movement by engaging in both a railway and an economic blockade, Lordship. After a while, at around 7 p.m., some of the people present there started placing stones at passing vehicles, Lordship. Then I drove the vehicle to a secure place, Lordship, and I learned that as the agitated people attacked so and so, Lordship. Five is the CRPF personnel, Lordship. Sri Vicky Kandapan, Lordship. A page 28, Lordship. Page 28. It's a witness number कितना दिया है? Page 15. नहीं 16 तो नहीं होगा. PW is not reflected, otherwise Lordship it is there, Lordship. My name and address mentioned above are true. I am the driver of the vehicle of the OC of the CRPF party. In the evening of 9/12/2019, I came to Sabuar railway station, and after making inquiry of my CRPF party, I could learn that so and so leader made a provocative speech against the government. The people assembled there got agitated, and some of the people vandalized passing vehicles by placing stone, Lordship, and that attack part, Lordship. Then my lord may kindly come to Lordship, PW 16, Lordship. Page 29, Lordship. My name and address recorded by the investigating officers are true. I drive vehicle of Sabua police station in the afternoon of so and so. As per the instruction of the officer in charge, I dropped him and accompanying police party at the Sabua Sareli. After parking the vehicle along with the roadside, I remained seated inside. At that time, a large crowd gathered near the railway station where a rally was going on regarding a rail Roku movement, railway blockade. As soon as KMS leader so and so finished his speech, some people began vandalizing passing vehicles by placing stones. When the police personnel tried to stop them, the agitated crowd attacked the police party with stones, and in the attack, the so and so was injured, Lordship. Then, Lordship, doctor's statement is there, Lordship, PW 19, page 34, Lordship. My lord may pay before that, my lord may page 32, PW 18, Lordship. Lordship, page 32, Lordship. It's a local correspondence of Proceeding time, Lordship. Statement of Biswajit Thukon, Lordship, page 32, Lordship. Is a PW 18. My name and address is stated above. I am a local correspondent of Proceeding time. During CAP, which has become CA now, I was in Sabua on 9th of December. Assam Bond call was given by the Krikhak Mukti Sangam Samiti and other organization. On that day at evening time, there were huge gathering of Sabua town comprising of at least 6,000 crowded, and Akhil Gogoi and some of his companions arrived at the meeting venue at 6 p.m. The meeting was arranged near Sabua rail station. As soon as Akhil Gogoi arrived, he asked people to sit in the railway track and block the rails. After some time, while the provocating lecture of chief guest Akhil Gogoi was going on, people get more furious and started planting stones upon the security personnel. Seeing the hue and cry, I rushed towards the main route of NS-37 where the security personnel were mainly present. On the way, I saw OC so-and-so sustain injury on his face and bleeding. He told me that he was hit because of plating of stones by the supporters of the Akhil Gogoi. I took the video footage of the injured OC as well as the meeting environment. Akhil lectures was still going on. There was no peaceful environment, although the environment was already noisy. One bolero was damaged, and there because of the instigation speech delivered by Akhil Gogoi. The bolero belongs to the security personnel, probably the CRPF. Lossi. Question was also put to him, Lossi. Who took the who took the lead of gathering so many crowd of the venue, Lossi? I think it was answer was given, Lordship. I think it was the organizer into the KMSS who gathered so many public there. It should be their responsibility the make of the environment peaceful. At least Akhil could have managed the situation, so he was the only guest lecturer. After the vandalism, Akhil and others remained an hour there, Lordship. Questions. What was the gist of the speech of so-and-so at the meeting, Lordship? Answer. It was against government and he warned people against the probable infiltration of Bangladesh into Assam and asked all to intensify the protest. Then, Lordship, another question. Did Akhil requested the crowd not to vandalize? Answer. I did not see, Lordship. Akhil Gogoi is an influential person and can provoke crowd by his strong voice. It is also seen that soon after the arrest and judicial detention of the accused so-and-so, some neutral witnesses acquainted with the facts of the case are willing to come forward and will surely cooperate with the entire investigation process. Therefore, his judicial custody, so that part is the. Then, Lordship, my lord may kindly come to next page PW 19, Lordship.
Doctor.
Dr. Lordship. Dr. Sinmoy Ranjan Joshi, Lordship. He is a Doctor in the Lordship, Aditya Multi-Specialist Dental Clinic, Dibrugarh, Lordship. On being asked, I further stated that on 9/12/2019, I received one call from Casualty Department at about 8 p.m. in evening regarding one emergency case of stone plating injury of one police officer. Accordingly, I attended the patient Sri Tulumoni SI Sri Tulumoni Dora OC Sabua Police Station at around 8:30 p.m. and I found there was 4x4 cm a 4 cm laceration over his right upper lip region, and he had a mobile fracture segment in relation to Lossi. That this part they have drawing up Lossi. And number 2 tooth cone was fractured. So we had removed the fractured part. Later on, we did investigation such as CT scan in the face. The final diagnosis was dentovelar fracture of so and so of the soft tissue, Lordship. Then treatment done, Lordship. Number 1, a soft tissue repair done so and so, Lordship, and 2 close reductions of the dentovelar fractures, Lordship. That is there, Lordship. Then my lord may kindly come to next page is a statement of Lordship Manasi Borua, Lordship. is a cyber cell inspector lawsuit, SI programmer lawsuit. PW20 lawsuit. On being asked, I further state that on dated so and so, NIA team from Gauhati came to cyber cell office of the Superintendent of Police Dibrugarh, Assam. On their requisition, I extract 8 numbers of video footage of violent activities of the KMS and SMSS, their associates from 9th December 2019 and onwards in jurisdictions of the Sabua police station, which were stored in the computer system of the cyber cell office of the Superintendent of Police Dibrugarh, bearing so and so number lossi, and preserved into pen drive lossi. And both pen drive were produced by me to Sri Prem Krishan Kakoti, Inspector Nia Gauhati, and he has sealed and seized both pen drive lossi into separate packets by preparing production cum seizure memo in presence of 2 witnesses. I put my signature on the production cum seizure memo as a producer. I also issued one certificate under section 65B4C of the Indian Evidence Act. Then my lord may page 37 PW21 lossi.
Just a minute.
Sorry lossi. To 13. Then 14 right on. 14.
Yes.
Then Lordship, paragraph 35 to 40 Lordship.
Okay.
Paper book Lordship. The
Not paragraph, page.
sorry, Lordship.
Yes.
Page 35 to 40 Lordship. Paper book PW 20/1 to Lordship. PW 22/2 Lordship. All other technical businesses Lordship.
22.
20/1 Lordship. To Lordship page 40 up to 40 Lordship. PW 22 to Lordship.
22.
22 to Lordship.
All are technical. All technical.
All other technical evidence Lordship. Technical
Witnesses.
Lordship. Then my lord may kindly come to page 41, PW 23 Lordship.
How many statements were recorded?
Lordship. 142 Lordship. What? 42. Only total 42 Lordship.
42.
42 Lordship. Last two witnesses regarding that Bengali community. I will place it also Lordship.
42 witnesses.
42. Total 42 Lordship.
Now, we are going in details. But what was the primary consideration of the learned trial court to come to a conclusion that no substance are there to frame the charges?
Lordship. Honorable trial court has said that Lordship, the materials which was placed before the trial court is not sufficient.
That we have understood. On what basis?
They have said that the ingredients is not fulfilled, Lordship. Ingredients are not there, Lordship. Ingredients to substantiate the Lordship that particular section is not there. If Lordship permit, I can read the Lordship the portions of the judgment also, Lordship.
Yes, which part?
Lordship. So, Lordship, just 2-3 witnesses there, just
Okay,
after
okay,
the
okay.
Then Lordship, that community part also Lordship indicated, I will place it, Lordship. Two part. Lordship, PW 23, page 41, Lordship. It's a Biki Kondopan Lordship, it's a CRPF officials Lordship. Second paragraph, I am starting Lordship. On 9/12/2019, I took company commander and deputy superintendent of CRPF from his camp to Sabua PS Lordship. The company commander of CRPF party left from Thana by bus towards protest place at Sabua, and most of the time of the day I remain in Thana. At about 6:30 to 6:45 p.m., the company commander CRPF called me, and accordingly I went their duty place in highway, which was a little distance from the meeting place towards Tinsukia. I parked my vehicle near the road on railway line side. At that time, near my vehicle, there was not much crowd. As soon as I parked the vehicle, I noticed in a distance about 100 meters towards meeting place, one gypsy vehicle was coming in the highway, and large number of violent protesters start and ran behind it and attacked it by plating stones, etc. Looking at the dangerous situation, I tried to divert my vehicle from that place, but already crowded came out from both sides of the road and blocked my vehicle. Violent protesters already start plating stones in my vehicle, and some of them attacked and tried to pull me out from the vehicle. Somehow I came out from the vehicle and ran towards market side of the town and hide under some buses and save myself. From my hiding place, I called the company commander CRPF, and about after 10 minutes, he assured me and asked me to come out. So I came out and reached near the vehicle. I saw that both windshields, one looking mirror and all glasses of left side were break by the violent protesters, and they also caused damages in the body of the vehicle. At that time, I called OC sir, but from him, I came to know that he himself sustained injuries in his face, Lordship, caused by some violent protester. Due to darkness and there was huge crowd, I could not identify any of the protesters clearly. I drove my vehicle up to Thana and parked it there. I was informed the matter to the owner of the vehicle. In this regard, perhaps company commander has submitted one complaint at Sabua PS. At about 1 week later, I, along with owner of the vehicle, took from the owner of the vehicle took from the Thana after doing all legal formalities and put it in garage. I do not know how much does it cost, so and so lordship. Then statement of Tilson Behera lordship, PW 24 lordship. He also has CRPF personal lordship. I am as above stated that next second paragraph I read it lordship. At around 1800 hours, Akhil Gogoi along with his associates came to Sabua near railway station incident place and addressed the crowd. During his addressing the crowd, he delivered the provocative speech to the crowd and told the people to oppose this bill and using any means, whether they had to do anything for it. On his provocation, some people from the crowd started planting stones and one stone hit on the mouth of the so and so, that part reiterated lordship. Then 25 also lordship, similar line lordship. 26 also lordship. Then my lord, page 48 lordship. PW 29. PW 29 lordship. Statement of lordship, Satish Borwa lordship. The station superintendent, Sabua lordship. May I read it lordship?
Page?
Page 48 lordship.
Yes, period 29.
Lordship. Satish Borwa, station superintendent, Sabua railway station lordship. On being asked, I further stated that on 9/12/2019, I pick up my shift duty at around 1830 hours lordship. Before that, Sri Kaushik Haldar ASM was on duty, and during his duty time, he told me over phone that there was a large number of picketers of anti-cab movement gathering the Sabua town and railway station. Also, they were planning to block the movement of Rajdhani Express number so and so lordship and up Kamrup Express number so and so lordship. After getting that information, I become alarmed and after getting that information, I become alarmed, and when I reached station, found that large number of crowd present in station platform and railway track and near the civil areas lordship. The message I received that down Naharlagun Express was already detained at outside the Sabwa station. Kamrup Express was detained in Dikkom railway station. Rajdhani Express was controlled at Dibugai station for precautionary measure lordship. And when I pick up my duty protest, program was continuing at platform and stations area and large number of protesters present there. For my duty as well as out of fear, I was remain inside my office, and from there I saw different leaders of various organizations delivered lectures, but personally I could not identify any of them. I also sent control messages addressing to the OC RPF so and so and security control New Tinisukia and concern around lordship 2100 hours lordship. The program finally finished after almost 8 p.m. and the Naharlagun Express arrived Sabwa station at around 10:30 p.m. From next day onwards, law and order situation become worse, and my reliever unable to came for duties. So I continue my duty till 5 a.m. of 11/12/2019 lordship. Even lordship not unable to move from the office also lordship. From 9 to 11 lordship. Finally, my reliever Sri Ramesh Kumar came to relieve me after 5 a.m. I went back my home. Later on, I came to know that situation became more violent on 11/12/2019. Miscreants set fire of a subway station and damages considerable losses. And on duty, ASM Sri Suvensu shut down the station and left lordship. Due to law and order situation, I could not come out from my
Just a
home.
minute.
I think it's a- Article 132. And the-
A1 was arrested
Lordship,
when
A1 did the was arrested.
and other accused.
Other all four accused were arrested, Lordship, but two are not arrested.
When they were arrested
They
on
were
9th or
arrested.
10th.
Lordship, I'll keep those. I verified and give those. In charge sheet, Lordship, page 71, it is reflected, Lordship. Page 71, 15.5, Lordship. Serial number 15.5, Lordship. Page 71, Lordship. They were arrested on date was given, Lordship. If Lordship permit, I can read it, Lordship. Lordship, Akhil Gogoi was arrested on 1/4/2020, Lordship. And Jagjit Gohai was arrested on 19/2/2020, Lordship. 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 15.5, Lordship. Then, my lord, page 48, Lordship.
What another point which my brother was pointing out, if you are, when you are reading page 48,
Lordship.
we are primarily concerned with an incident of 9th
Lordship.
evening,
Lordship. Lordship.
because the entire FIR and the investigation is
Lordship,
confined to that incident.
Lordship.
If you read 48 narration,
Lordship. It's up to 12, Lordship. Up to 13.
not only on that day, that program had finished at around 8 p.m.
Lordship.
and the Naharlagun Express arrived at Chabua station at 10:30.
Lordship.
From next day onwards, law and order situation became worse, and my reliever unable to come for duty
Yes.
and continued
Yes.
till 5 a.m.
Yes.
of 11/12/2019. Finally, my reliever came. So these are subsequent events
Subsequent.
for which perhaps there would be some other information lodged.
Lordship.
We are not on those.
Not on the otherwise, Lordship.
We are only on the 9th incident.
Only on 9, Lordship. And Lordship, yes, because the persons he have given that statement, because he came to the office to join the duty on 9, Lordship. But due to the protest, Lordship, he unable to move from the office up to 11, Lordship.
Who is reliever? Raman Kumar.
His reliever is come on 11 only, Lordship.
What is his name? Raman Kumar.
Lordship.
Raman is there as a witness here.
Raman Kumar, Lordship, I'll verify it. Raman Kumar, can you verify? Then Lordship, PW30 Lordship, the PWD contractor Lordship. Deborki Setia Lordship.
Page
Page 50 Lordship.
50.
50 Lordship. Raman. Probably in the list of witnesses, Lordship, he's not there, Raman Lordship. I'll inform him, Lordship. Here, Lordship, Deborki Setia. I am as above mentioned on being asked, I state that by profession, I am a class 1B contractor of the PWD routes, and I am as the Assistant General Secretary, Center Units Motop Jubosatto Sonmilan in the year 2018, probably in the month of October, November, almost 70 various organizations from defined communities, local club, ladies organization, etc. of Sabua area comes under one umbrella organization called Nagorik Songot Nagorik Nagorik Songodhani Bidhayok Nagorikotto Songodhani Bidhayok 2016 Birut Mons Lordship to fight against CAP together and came MSS leader so and so, retired professor of Nehu and Sri so and some other prominent leaders of various organizations were present there also. On being asked, I further stated that unlike other organizations, under this umbrella, our organization should took part in the various protest programs in different places. But when the CAP movement, the CAP about to pass in Rajya Sabha, the movement became more intensified during the period of October 2019 till its end. Various organizations, including our organizations, under umbrella of the Nagorikotto Sanghodhani Bidhayak Biroti Mancho 2016, it's 2016 planning for various protest programs, including Rail Roko protest march, meeting, etc. Accordingly, on 9/12/2019, people from local areas start gathering at near Sabua railway station and market area at around 5:40/6 p.m. Different leaders from various organizations like so and so, etc. began to deliver their lectures regarding protests against CAPE, where KMS leaders so and others also delivered aggressive and provocative speeches. In that program, larger number of people came out voluntarily in that meeting place, due to which road traffic were disrupted, but I, along with other organizers, tried to clear the highway. The program of Rail Loku was there, and as per my knowledge, no permission from civil authority was taken for organized protests/meeting programs in Sabua on 9/12/2019. During that time, ADC so and some other informed me about some protesters were trying to create violence near the meeting place and to disturb law and order situation. At around 6:45 p.m., I heard one message that one CRPF vehicle was damaged by some protesters at about half kilometers from the meeting place towards Panitula side. At that time, Sri Tulumoni Duara, SIOC Sabua police station, along with his staff, were near to me in his duty. As soon as he received the news, he, along with the staff, went towards the place of occurrence where the CRPF vehicle was damaged. And I, along with few of my companions, followed him. When I reached the place, I saw OC sir was attacked by protesters, causing serious injuries on his face due to the stone plating. At that time, I saw so and so were along with other protesters near the damaged vehicle, and while I tried to remove one burning tire from the road, so and so hit on tire with a sword that is there, with a sword, or which he was carrying, and so were leading the mob, It is the lordship one of the part organization who took part in the lordship that program, Then my lord, next page is 52 PW 31, Dhurbo Guhai, He is also one of the office bearer of the DYFY, It's a CPIM public organization. So paragraph 2 onwards I read it, On being asked, I further state that unlike other organizations under this umbrella, our organization also took part in various protest programs in different places. But when the CAPE about to pass in Rajya Sabha, the movement became more intensified from October 2019. Various organizations, including our organization, under umbrella of the Nagorikotto Sanghodhani Bidhayak Birodhi Monch 2016, planning for various protest programs, including Rail Ruku protest march, meeting, etc. Accordingly, on 9/12/2019, people from the local area start gathering at near Sabua railway station and market area at around 5:40 to 6 p.m. Defined leaders from various organizations like so and so began to deliver their lectures regarding protests against CAPE, where KMS leaders so and others also delivered aggressive and provocative speech. In that program, large number of people came out voluntarily in that meeting place, due to which road traffic was disrupted, but I, along with other organizations, tried to clear the highway. But our program was to railway ruku. So we blocked the railway track. No one from our organization or other organization working under the umbrella of Nagorikotto Sanghodhani Bideyok Beauty Monso 2016 took prior permission from the district authority to conduct any public meeting to protest program, etc. In Sabua area on 9/12/2019. When the program was going on, I have heard that one CRPF vehicle, similar stories there also. Then my lord may kindly come to page 56, lordship. PW 34, lordship. Page 56. He is a lordship, one of the employee of the lordship, NF Railway, Kosik Haldar, lordship. I am as above mentioned on being asked, I am to state that I joined the NF Railway on 25/5/2016 and so, lordship. And I joined the Sabua railway station as station master on 24/11/2019, lordship. On being asked, I stated that on 9/12/2019, I had duty from 6 hours to 1800 hours. At around 1500 to 1530 hours, some people came to my office and told me not to allow the train number 15907 down Naharlagun Express to come to station as because they are planning to rail ruku program and other protest program in Sabua railway station. I was newly posted in Sabua and I have lung problem also, so I could not identify any of them clearly. I was afraid and nervous and informed the matter to my divisional control Tinsukia. I asked my gateman to know the ground situation, who replied that there were about 200 to 300 people assembled near the signal. So it was impossible to operate signal for above 10 lordship. On that, for safety and security of passengers, me and my other staff, as well as safety of railway properties, I decided to stop the train outside the signal. As long as time passed, number of protesters began to increase in station area as well as nearby civil areas. Large number of protesters sit on the railway track and observe the rail loco program and by holding banners and shouting different slogans. As I told you already that due to language problem and being newcomer in Sabua, I could not understand the slogans clearly, nor I could recognize any particular person in the crowd. Even though I secretly took few photographs of crowd in my mobile, at around 17:45 hours, one meeting was started in the railway platform in Tinsukia at Tinsukia End, Lordship, where various leaders from different organizations began to address to large number of protesters. Due to my own safety and security, I could not take photographs of them and unable to recognize any of them clearly. My reliever, Sri Satish Borua, came at 18 hours and I handed over my duty to him and briefed him about the situation. After that, I went hurriedly to my rented house in Sabua, Lordship. And Lordship, next part, it is next day incident was reiterated, Lordship. And I remain then, Lordship, next page. I remain inside my home. From my home, I get the news of deteriorating the law and order situation in civil areas. So I remain inside my home and I got the news of burning and damage of subway station on 10/12/2019. On 11/12/2019 at around 5 a.m. in the morning, I went to the station and saw the station building was badly damaged, Lordship, and burned down and caused heavy losses to the railway properties, Lordship. And then, Lordship, 35 also, Lordship, same. It's a railway employee. Yes, technical, Lordship, technical evidence, Lordship. technical witnesses, 35, 36, and 37 Lordship. All are technical evidence, Lordship. Even Lordship 38 also.
Yes.
Then Lordship 62. 62 regarding the person says that the accused person he have personally known Lordship. Statement of deputy Henrik Lordship. On being asked, I have stated that page 62 Lordship. I have stated that I know the following persons personally.
Who is he?
Lordship, he is working as a mechanical air coordinator in the Rajabari area, Lordship. Bhupen Gogoi, Jagjit Gohai, so and so, Lordship. Further, I have to state that I had a talk with Bhupen Gogoi, Jagjit Gohai, and Bhaskarjit Phukan many times over their mobile phones number as above. They are the relatives, Lordship. He identified the mobile phone numbers as well, Lordship. And statement of Abhijit Gohai is also there regarding Lordship. Personally, he known the accused persons and he also talked with their mobile phones. That part is there, Lordship. Then Lordship, regarding that part, Lordship, the planning to burn part, Lordship, PW 41, Lordship, page 64, Lordship. Statement of Lordship, Sri Ronak Sah,
Page?
page 64, Lordship, PW 41, Lordship. I am as above mentioned. On being asked, I state that I have completed so and so, so and so. I have been working in technical side of the Airtel company since 2013. I also do supply business of transportation. I am living with my family and with my mother in the above mentioned address, Lordship. On being asked, I further state that on 9/12/2019, during daytime, when I heard the news of protest program and rail loco scheduled to be held in the evening, led by so and other leader of the several organization, I became afraid and decided to remain inside my house and keep my other family members to be remain inside the home. I also decided not to run any commercial vehicle and park all vehicles in safe places. I belongs to the Hindi speaking community. I feel insecure where and particularly in such situation there is every possibility that we are victimized in hand of local people. So for safety security for me and my family members as well as my properties, I decided to remain inside my home till almost 1 week. From my home, I came to know that the violence caused by violent protesters in Sabua and nearby areas, neighborhood in the TV also. Then my lord, next page 65, PW 42 Lordship. Josat Ali Lordship. He is a Lordship daily wage laborer Lordship. On being asked, I further state that on 9/12/2019, during daytime, when I heard the news of protest program and rail loco scheduled to be held in that evening in Sabua, organized by leaders of several organizations, I became afraid and decided to remain inside my house and keep my other family members to remain inside the home. I belong from Hindi-speaking community. I feel insecure where and particularly in such situation, there is every possibility that we are victimized in the hand of the local people. So for safety security of me and my family members, I decided to remain inside my home from 9/12/2019 till almost 1 week. From my home, that same story is narrated also. Regarding discussion and analysis part, my lord have indicated lawsuit. It is in page 135 lawsuit. Page 135 lawsuit. Para 45 onwards, if lordship permit, I can read it lawsuit.
Whereas,
Para 45 lawsuit.
that is 130, it's not be 130, 130, yes, 135.
Page number.
Yes.
35. Analysis of materials and conclusion on the point of search with regard to A1 so and so lawsuit.
Yes.
Amongst the witnesses examined by the police during investigation, I find that protected witness A and witnesses number 2, 3, 17, 18, and 30 are some of the eyewitnesses to the LS incident. All these witnesses have stated that on 9/12/2019 in the evening, there was a last gathering at Sabua near Sabua railway station, which was also addressed by A1, and that he gave provocative speeches there, and subsequently the crowd turned violent and started pelting stones, one of which hit the witnesses number 2, say so-and-so informant cum victim, grievously injuring his face and teeth. The nature of the injuries sustained by the informant is clear from the medical evidence on records and the statement of witnesses number 19, Dr. C.R. Joshi, a dental surgeon of Dibrugarh. The witnesses have not stated that A1 has directly incited the violence, but they have stated that he delivered provocative speeches whereafter the crowd turned violent. Protected witnesses A has also stated that after the crowd turned violent, A1 did not denounce it or did anything to stop it. Witnesses number 2, informant cum victim, has also stated that when after sustaining injuries, he was being shifted away from the site, A1 was still addressing the gathering. In his statement, witnesses 18, C. So-and-so, a TV journalist, stated that after vandalizing, A1 and others remained in the site for an hour, and that these witnesses did not see A1 requesting the crowd not to be vandalized. Then 46 lawsuit. Witnesses number 5 and 8 have stated that the crowd led by so-and-so started pelting stones in the police party, but some of the other witnesses have stated that so-and-so delivered an aggressive and provocative speech, and subsequently some members of the crowd started pelting stones on the police party. Therefore, I find some differences in the nature of the incidents narrated by these two sets of witnesses. Further, several of the witnesses have stated that they could not recognize the protesters who had thrown stones on the police party, leading to the injuries on the OC Sabua police station. Then 47 lawsuit. The statement of witnesses, Sri Deborsi Setia, that the accused persons, including A1, was leading to the mob is not corroborated by similar statement on that part of other witnesses about the accused persons leading the mob. Further, some of the witnesses attributed vandalism on the part of the protesters instead of attributing it to A1. Some of the witnesses have also stated that they did not know the attacking person, and some other witnesses have stated that they could not recognize the attacking protesters in dark. Some witnesses have simply stated that some protesters in the crowd pelted stones. 48 lawsuit. In the context of statements of a few witnesses that A1 gave a provocative speech to the crowd which turned violent, the contents of speech available in the document D29 is most important and correlate in the two. In this regard, upon perusing the speeches A1 from D29, I find that though it contains some sharp political statements and criticism with regard to the case, there is no incitement to violence. I also did not find any incitement/instigation to damage property or obstruct public official. Considering the contents of speeches available in the D29 and the statement of the witnesses, about provocative speech, it appears that the tone and tenor of the speech might have been aggressive on the issue of Ka rather than the speech directly inciting violence. After noticing the contents of the speeches of A1 from D29, I find a contradiction with statement of one or two witnesses about A1 leading violent mob throwing stones.
Yes.
Lordship. Then 49, Lordship. If the contents of the speech of the A1 so and so do not contain instigation of violence, etc., simply the statements by some of the witnesses about A1 giving provocative speeches leading to violence could not rely on, in my considered view, to impose criminal liability on A1C so and so. In the large gathering where speeches were delivered on contentious issues, it is possible for the crowd to get excited and some unruly elements therein might take undue advantage of the situation to indulge the unacceptable behavior. The omission on the part of A1 as revealed by the statements of some of the witnesses is that after some vandalism started, he did not do anything to stop it. However, in my considered view, that in itself would not impose criminal liability on him within bracket A1, though it might have been his moral responsibility to try and do something about it, Lordship. Then 50, Lordship. Next page. As far as the documents with regard to A1 are concerned, document D15 contains the transcript of telephone conversation with A1 with various persons. D49 is the CDR analysis report of the mobile numbers of the accused person, including A1. The telephone conversation and CDR reports no doubt indicate that A1 was present in Sabua on 9/12/2019 and also about organizing protest against CAP. However, from the telephone conversation, I do not find anything incriminating regarding any commission of offense or any conspiracy, Lordship. And paragraph 51 regarding, Lordship, bail granted parties there, Lordship. And paragraph 52, Lordship, the law decided by the apex court is reiterated here, Lordship. Bail, Lordship. Paragraph 53, Lordship. Paragraph 53, Lordship. In view of the materials on record as discussed above, I am of the considered opinion that the omission and commission of A1 revealed by the materials cannot be prima facie said to be a terrorist act done with the intention of threatening unity, integrity, and sovereignty and security of India, or a terrorist act done with the intention to strike terror in the people. Therefore, from the aforesaid deduction, I am of the considered view that
Yes.
it cannot be said that there are no sufficient materials prima facie of framing charge against the accused A1 so and so so and so.
No, this, I think this line has
This-
not been properly framed.
This line not properly said.
Not properly framed, I think.
Lordship, it cannot be. Then Lordship,
Therefore, from the aforesaid, I am of the considered view that it cannot be said that there are sufficient grounds.
two negative, positive, Lordship.
No,
Lordship,
that is a
typographical
typographical.
Lordship.
At times expressions, we also make mistake in
Lordship,
expressions.
Lordship. While arriving at the appropriate deduction regarding non-existence of the prima facie materials for framing charge against the accused under the UAPA Act 1967, The court has kept in mind the principles of law laid down in para 12 of the Johor Ahmed Shah Waterly, that the degree of satisfaction with regard to the UAPA Act for the purpose of search pending is higher, and that while adjudicating bail lawsuit. Despite the statement, next page, lawsuit 55. Despite of the statements of informant so and so, and in view of the other materials on record, I am of the considered view that it is not possible to come to a prima facie finding for the purpose of framing charge that A1 was part of an unlawful assembly which injures the informant, and therefore it could not be justified to try A1 for the offense under section so and so lawsuit. And 56 lawsuit. On the basis of the materials, I also do not find a
Just a minute.
lawsuit.
Yes.
On the basis of the materials, I also do not find paragraph 56. On the basis of the materials, I also do not find any prima facie case for the purpose of framing search to hold A1 personally criminally liable for offences of rioting, unlawful assembly, causing damage to property, causing hurt to the public official on duty. 57. Thus, on the basis of the materials on record, I am of the considered view that the same is inadequate to frame charges against the accused A1 for the offence of IPC narrated in the charge sheet for other IPC offences, Lordship. Then paragraph 58, Lordship. In this regard, I also refer the principles of law laid down by the Honorable Supreme Court in Sajjan Kumar, that the two views are possible and there is no grave suspicion a court would be justified to discharge the accused, Lordship. Then 59, Lordship. Consequently, in view of the above discussion, I am of the considered finding that the materials are inadequate to attribute any act of the terrorism to A1 to frame charges against him under the UPA Act 1967. I also come to the considered finding that there is no justification to frame charges against A1 so and so under the cited penal provisions of IPC and other penal sections, and that he is liable to be discharged. This is the finding against the lawsuit A1 lawsuit. Then lawsuit A2. Analysis of materials and conclusion on the point of search with regard to the A2, Sri Jagjit Guhai lawsuit. 60 lawsuit. The main incriminating materials against A2 is in the statement of the Devorki Setia, wherein it is stated that A2 along with A1, A3 and A4 were leading the mob. But similar statements has not made by any of the other witnesses, including C so-and-so. In fact, informant so-and-so has only stated that A2 was present in the gathering along with others. Though C so-and-so had stated that A1 and his associates criminally conspired against them, throwing stones and obstructing police and government officials, he has not mentioned who those associates were. Similarly, he has also stated that the associates of A1 damaged the Bolero vehicle on duty. In this regard, witnesses Sri Devorki Setia also stated that A2 along with other co-accused and protesters were near the damaged vehicle. The telephone conversation with regard to the A2 available in document D15 do not have any incriminating materials in my considered view, and the said conversations are rather inaccurate. On the base 61, on the basis of the aforesaid materials, I am of the considered view that There are no materials whatsoever regarding criminal conspiracy against A2. The materials also do not make out any prima facie case of framing charge of offense of terrorism under UPA Act 1967 against A2. While doing so, the court has kept in mind principles laid down in para 23 of the authority as mentioned earlier, Lordship. Paragraph 62, Lordship. As stated earlier, the statements of witnesses Sri Setia about A2 leading mob do not find support elsewhere, and the statement of witnesses Setia about A2 being present near the damaged vehicle and the statement of informant Sri Dora about A2 being present in the gathering is inadequate. With regard to the other penal section of IPC, though the injuries sustained by the police officials are extremely unfortunate, but the materials on records are grossly inadequate to frame charges against A2 for any offense of grievous hurt or attempting to murder.
Okay, we'll continue.
Lordship.
143.
143.
Yes, we are at 143.
Paragraph 62, Lordship. As stated earlier, the statement of witnesses C. Setia about A2 leading mobs do not find support elsewhere, and the statement of witnesses Setia about A2 being present near a damaged vehicle and the statement of informant C. Dora about A2 being present in the gathering is inadequate. With regard to the other penal section of the IPC, though the injuries sustained by the police officials are extremely unfortunate, but the materials on record are grossly inadequate to frame charges against A2 for any offense of grievous hurt or attempt to murder, simpliciter, or with aid of the section 149 IPC when aggressive speeches were delivered in the midst of the large gathering on a contentious issues. It is not surprising if parts of the crowd got excited and taking undue advantages of the said situation. Some miscreants from the crowd indulged in condemnable unruly behavior. However, in offense involving crowd and vicarious criminal liability, the court will have to guard against mistaken implication or prosecutions, not just in the trial but even in the stage of framing of charges, Lordship. Then 63, Lordship. I also refer to the principles laid down by the Honorable Supreme Court in Sajjan Kumar that when two views are possible and there is no grave suspicion, the court would be justified to discharge an accused. Thus, on the basis of the materials available on record and with regard to the A2 Sri Jagjit Guhai, I am of the considered finding that same would not justify framing of charges against A2 under the charge-sheeted penal provisions or other penal section, and hence A2 is liable to be discharged. Then my lord may kindly come to in respect of A3, Lordship. 65. Witnesses Devorsi Setia in his statement stated that he saw A3 along with other protesters near a damaged vehicle, and that when the witnesses tried to remove one burning tire, A3 hit the tire with the sword which he has been carried. This has been corroborated by document D48 and D53 photo identification memos, wherein photographs F, A, and C indicates A3 carrying a sword. D74 scrutiny of the videos also indicates A3 running with protesters carrying sword in one hand. 66. Despite the statement of the informant Sri Tulumani Dora, in view of the other materials on record, I am of the considered view that it is not possible to come to prima facie finding for the purpose of framing of charges that A3 was part of the unlawful assembly which injurious the informant, and therefore it would not be justified to try A3 for offense under section 326 and 307 of IPC with the aid of section 149 IP. However, the materials, including the photographs, do make out a prima facie case about being member of the unlawful assembly in that area and indulging in rioting armed with the deadly weapon, Lordship. On the basis of the above materials on record with regard to A3 Sri Bhaskarjit Phukon, I am of the considered finding that materials are prima facie sufficient to frame charges for an offense of rioting armed with deadly weapon as part of an unlawful assembly punishable under section so and so, Lordship. As regards the other materials against A3, they are similar to that with regard to A2. Therefore, I am of the considered view that these other materials are not sufficient to frame charges against A3 under other penal section, including that the conspiracy and terrorism lawsuit. Then lawsuit analysis of materials and conclusion in respect of A4 lawsuit. 69. The main incriminating materials against A4 is the statement of Deborsi Setia, wherein he is stated that A4 along with A1, A2, and A3 were leading the mobs. But similar statement has not been made by any of the other witnesses, including Sri so-and-so. In fact, informant Sri Tulumoni Dora has only stated that A4 was present in the gathering along with others. Though Sri Tulumoni Dora has stated about A1 and his associates criminally conspired against them, throwing stones and obstructing police and government officials, he has not mentioned who those associates were. Similarly, he has only stated that the associates of A1 damages the Bolero vehicle on duty. In this regard, witnesses Sri Deborsi Setia also stated that A4 along with the other co-accused and protesters were near the damaged vehicle. Document D15 does not have any telephone conversation with regard to A4. Paragraph 70 also next page. Document D48 contains a photograph stating that A4 has been identified therein with both hands raised and holding a fist on the side of the capsized vehicle, and however, on the basis of the same, one cannot, in my considered view, come to the conclusion that A4 was responsible for damaging the vehicle also. Then 71 lawsuit, as stated earlier, the statement of witnesses Sri Setia about A4 leading mob do not find support elsewhere, and the statement of witnesses Setia about A4 being present near a damaged vehicle, and the statement of the informant Sri Dora about A4 being present in the gathering is inadequate. With regard to the other penal section of the IPC, despite the statement of informant Sri Tulumoni Dora in view of the other materials on record, I have the considered view that it is not possible to come to a prima facie finding for the purpose of framing of charge that A4 was part of the unlawful assembly which injured the informant. Though the injuries sustained by the police officials are extremely unfortunate, but the materials on records are inadequate to frame charges against A4 from any offense of grievous hurt or attempt to murder, simpliciter, or with aid of section 149 IPC. As mentioned earlier, in offenses involving crowd and vicarious criminal liability, the court will have to guard against mistaken implication or prosecution not just in the trial but even in the stage of the framing of charges lawsuit. 72. I also do not find a prima facie cases for the purpose of framing charges to hold A4 personally or vicariously criminally liable for offenses rioting, unlawful assembly, causing damages to property, causing hurt to the public official on duty. 73 lawsuit. On the basis of the aforesaid materials, I am of the considered view that there are no materials whatsoever regarding criminal conspiracy against A4. The materials also do not make out any offenses terrorism against A4 under UAPA Act 1967 for the purpose of framing of charges, keeping in mind the principles laid down in para 22 of Atoli as mentioned earlier also. I also refer to the principles of law laid down by the Honorable Supreme Court in Sajjan Kumar that when two views are possible and there is no grave suspicion, the court would be justified to discharge the accused. Thus, I am of the considered finding that the materials with regard to A4 so-and-so would not justify framing of charge against A4 under the charge-sheeted penal provisions or other penal section, and hence A4 is liable to be discharged also. Then final orders and point of charge lawsuit. 76. Accordingly, in view of the aforesaid findings, three of the accused person, namely A1 so-and-so, A2 so-and-so, and A4 so-and-so, are hereby discharged. The bail bond stands sureties with regard to A1, A2, A4 stand discharged. The accused UTP A4 Sri Bitupon Gogoi shall be set at liberty forthwith if not wanted in any other cases. Then, my lord, my next page, 77. However, charges are framed against the accused A3 Sri Bhaskarjit Phukon.
That we have read already.
Lordship.
It has been sent to the jurisdictional Syrian.
This is about the framing of charges lawsuit. And Lordship, in respect of Lordship, documentary evidence and videograph Lordship, the next date Lordship will place it Lordship. And regarding law point also Lordship. And in that the particular day, AG will be appearing.
Where is Mr. Bottom? Let me hear.
Documentary evidence in volume 2 starts Lordship, volume 2 and volume 3 is there Lordship.
As you have told, the learned trial court
Lordship,
had also looked into the videographs.
Lordship.
On the next date, you
Yes.
make sure that you have the arrangement to have the,
Lordship, will do.
if required, you can have in camera also.
Lordship, will do, Lordship, will do. I accordingly inform the official Lordship. Will do, Lordship, will do. No, 17 by 20. That, Lordship.
Mr. Gogoi, what are the principles which are required to be followed
Lordship, here,
at the time of framing of charge?
framing of such Lordship, the, as per the law, unable apex, but they cannot go the depth of the materials in the evidence part, Lordship. When mini trial cannot be conducted, Lordship.
Decision?
Decision is there, Lordship. We have the, we will place it, Lordship. Everything will place it, Lordship. We'll make a compilation and give it, Lordship.
What is the landmark judgment in this?
Lordship is there.
You can place it on the next, but you can, if you can give the citation.
Lordship, I will just. I will give the list of books also, Lordship. Here I
You give
will,
the landmark case, we'll just have a look.
Lordship. It's a 1979 TSCC 4, Lordship. 79
1979.
TSCC 4, Lordship.
Name?
Name, Lordship, Union of India versus Praful Kumar Samal, Lordship. Then, Lordship, so many, I will give the list, Lordship.
This is one of the landmarks.
Lordship. We almost 13 judgment we have prepared, Lordship, in
Okay.
that particular point, Lordship. In 2025 judgment also come, with that also we have.
Samal was the, it has arisen from the Orissa High Court, I think.
Lordship,
That case 79.
Lordship. Even Lordship, Johari's case also there, it is, it come from state of MP, Lordship.
You mark the paragraphs also.
Lordship, we will prepare, Lordship, compilation along with the paragraph, Lordship. And
Are not required for the entire judgments to be copied. You give the relevant page
Lordship, Lordship.
containing those paragraphs
Lordship,
and the
Lordship.
first page.
Lordship,
We'll
Lordship.
recheck from our
Lordship,
own
Lordship,
source.
Lordship. Just, we have just, that I think. We have prepared this way, Lordship, it will suffice, so Lordship, we will detail, we will do, Lordship.
No, this is okay, but you give the first
No,
page,
Lordship, we'll give.
only the first page, and that page where contains the paragraph.
Lordship, we'll do, Lordship, we'll do.
Page is full now. So, leave one item. This one, wait, one is highlighted. Yeah. We check the, maybe, very much number. People, with the stuff. This one, check it.
Correct. And this one also, lordship, cash loss, we have, on cash loss part, we will compile all the cash loss we have, lordship. Next page, lordship, the head notice there, lordship.
This for yours. In court number 1.
Yes, miss.
17 of 18. 17 of 18, okay. Lordship, on 17,
No, we'll hear Mr. Waterford.
Today, your lordship.
Yes.
Okay.
lordship, lordship.
The AG can give a rejoinder, and if there are points of law, we can still give an Waterford an
Lordship,
opportunity.
lordship,
Okay?
lordship, 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 lordship.
This is a specially assigned bench. We
Lordship,
have to
lordship.
complete this.
Lordship, lordship, lordship.
Your lordship, so far as this case is concerned, your lordship has already gone through the timeline of the case, your lordship. Your lordship will find the FIR, which is at page 1, your lordship. Your lordship has already gone through, and your lordship will see that initially this case was registered purely under IPC sections, your lordship. And those are, your lordship, 147, 120B, 147, 148, 149, 336, 350, 326, and 307 of the Indian Penal Code, your lordship. Now, your lordship, very interestingly, your lordship, subsequently, as has been reflected from the report, your lordship, UAP was invoked, your lordship. Now, if your lordship has gone through section 15 and till search sheet is filed, your lordship, no successive section under your lordship UAP was invoked in this particular case. 15, your lordship has already gone through. It is a definition of terrorist act. It is not a substantive offense, your lordship. It starts from 16 onwards, your lordship, in chapter 4. Till investigation is completed, search sheet is filed, your lordship. On that, your lordship, based on section 15, this investigation was continued, your lordship. This firstly shows the hurried nature of the invocation of UAPA, your lordship.
But that was not the subject matter of challenge.
No, that was not.
We were just discussing
Lordship.
the handing over of the matter to the NI by invoking UAP at a subsequent stage Was it put to challenge?
No, we have
It
not.
wasn't.
It was.
It wasn't.
It was.
And we have also discussed 15 and 16.
Lordship.
You may be correct in contending 16. 16 is the penal provision.
Yes.
But so just like analogy of 300 and 302, the charge is under 302, but you have to meet the requirements of 300.
300.
So it will not make much of a difference.
But your lordship to show that the way they have conducted the investigation, your lordship, that's
You had a chance, you should have or could have.
the lordship.
You haven't, but that will not preclude you from
Lord.
raising this. You have raised this. We have, in fact, we are aware of this. In fact, we had discussed this aspect.
Lords. Lords. Now, your lordship has gone through the statements of the witnesses, your lordship.
Hmm.
If your lordship permits, your lordship, since FIR your lordship has already gone through, I will not pray that it should be again. It fails. First, your lordship, protected witness A, your lordship. And before that, your lordship, what has emerged, your lordship, from the reading of the statement of the witnesses, one facts become very clear, your lordship, that so far as two very vital witnesses are concerned, who organized that particular meeting, your lordship, and your lordship will find two or three things there, your lordship. First of all, your lordship, that this meeting was not organized by the accused person, accused number one, or his organization alone, number one, your lordship. This was a meeting organized by various organizations together, number one. And from their statements, it becomes very clear that people are coming voluntarily, your lordship. That is a very vital aspect of the matter, your lordship. It was not, that means that it was not a meeting organized in such a manner. They have very clearly stated that this was a voluntary meeting. And in that particular meeting, apart from the accused number one, there are other leaders and intellectuals who participated, and according to them, the witnesses, that these persons also give provocative speech, but they have, your lordship, targeted only one, not others, although they are specifically named and the organizations are specifically named. In spite of that, only one person has been targeted, your lordship. That is a very vital aspect of the matter. And they have, in fact, if you go through travel through the statements of the witnesses, even the
Mr. Bhattakur, unfortunately, these are not the subject matter of discussion either in the trial court. We are only on the aspect of the legality, validity of an order of discharge.
lordship.
This is not an application or an appeal or a revision by you.
No, lordship, that's true, your lordship. But why I am submitting this, your lordship? Because
See,
your lordship,
you have to justify or defend the trial court's conclusion
lordship,
on the aspect whether there are materials, prima facie materials,
lordship,
to frame charges or not.
lordship. I will go to that, your lordship, but I am trying to.
You have to hit that.
Lordship.
That is the point where we are exploring.
Lordship. That I am trying to point out that, your lordship, that these statements of the witnesses, your lordship, it cannot be said, your lordship, that first of all, that there are materials, your lordship, which can bring him within the ambit of section 15, his act, number one. Number two, by selectively taking out with this similar kind of materials, by selectively taking out the number one and not considering the other persons who are organizing or participating in that particular meeting, the investigating agency and the prosecution, in fact, has failed to substantiate their case, your lordship, so far as the charge of terrorism is concerned. That's what I wanted to point out. And therefore, your lordship will find the statement to the protected witness one, your lordship. Only one protected witness A. At the end of the day, your lordship, we will have to link his speech, because, your lordship, whole case of the prosecution is that because of the provocative speech given by him, the occurrence of certain act by some other persons has taken place.
But it is consistently all are saying that there was a rail roko agitation.
Proceed.
There was a rail roko agitation.
Yes, rail roko agitation was there, but the point is, Your Lordship, where is the material to show that rail roko agitation was called by me? I have participated in that rail roko agitation. Is there any material before this honorable court to show that I asked them to go for rail roko agitation? Then
Those-
what they have said?
Those would be the subject matter of the prosecution in the trial.
No, Your Lordship, ultimately prima facie material is there or not. That Your Lordship will have to.
There are many, almost all the witnesses have said that they were called for a rail roko. In fact, 3-4 trains were halted.
Who have called for rail roko? That is not there. There is no statement.
This can be one of your defense, but can you say that prima facie you are not involved in this agitational program which has led to this activities? In fact, the veracity also we are not entering into at this moment.
Lordship,
We are only on the aspect whether there are prima facie case to go for a trial.
Your Lordship, kindly see, Your Lordship, at the end of the day, Your Lordship, so far as these materials are concerned, the allegation of the police is what? Allegation of police is that, Your Lordship, that by my speech, I have provoked people to cause violence, Your Lordship. Now, there will have to be a link between my speech and the act that has been done by the other persons, Your Lordship. Therefore, Your Lordship will have to go to the speech to see. And second, Your Lordship, as Your Lordship has fallen from Your Lordship's mouth, Your Lordship, on 9th, I was there for.
Mr. Bothakur, suppose in a given case the speech is not there is no videograph.
Lordship.
In a case there is no videograph or it was not recorded, then what would be the material? Can you say that there is no videograph, so we cannot proceed?
No, that is not there.
Can you just preempt the prosecution from even proceeding?
No,
It
Your
is-
Lord.
See, the prosecution, the entire burden is on the prosecution to prove beyond all reasonable doubt. Can you say that even that chance cannot be because there is prima facie, there is nothing, no recording is not there?
No, it is not recording. Recording is there. That is why.
No, in a given extreme case,
Extreme
case, recording is also not there.
No.
Can an accused say that there is no recording? How do you proceed?
If then Your Lordship corroborative evidence are there.
Exactly.
That's
So
the-
whether the statements are there prima facie at the stage of 161
Lordship.
to frame charges,
Lordship.
to file a charge sheet, which they have done.
Lordship.
On that you have to.
Lordship. Lordship, that is why, Your Lordship, my first contention is that, Your Lordship, that the materials as has been placed before the honorable courts by the prosecution and investigating agency, Your Lordship, on the face of it, does not make out a case for under section 15, Your Lordship, or section 16, Your Lordship. That is my first case, Your Lordship. And second, Your Lordship, the violence that had taken place on 10th, 11th, and 13th, Your Lordship. Where are the materials, Your Lordship, to link me with that violence, Your Lordship?
No, we are not on the subsequent event. We have made it very clear. Those may be subject matter of
Lordship.
some other affair. We
Lordship.
are only on the 9th incident.
Not. That is
We are
why.
on the 9th incident.
And whether, Your Lordship, rail reco, even assuming that I am part of the rail reco movement, whether on the face of my participation in a rail reco movement will amount to a terrorist act or not. And in my humble submission, that is not there.
What about the other, just out of the context,
Lordship.
what about the other, include the other offenses? Rioting, then causing hurt, grievous hurt to the police,
No, Your
then causing
Lordship.
damage to public property, 149, 141, 147. What about those?
Lordship will kindly see that on the face of it, there are, Your Lordship, materials on those sections. I am not saying that so far as the petitioner, but a person, an officer has, Your Lordship, received injuries, stone has been thrown, pelted, that these offenses probably will be, Your Lordship, there, Your Lordship. I don't deny that, Your Lordship. Whether that will come against these persons or not, that's a different matter, Your Lordship. But on the face of that, this affair, some cognizable efforts has been committed. But those cognizable, whether we can extend it to such extent, Your Lordship, that it will include UAPA, Your Lordship, which is a very stringent provision, Your Lordship, which has Your Lordship. And Your Lordship will kindly see, if Your Lordships pick up the UAPA for a moment, Your Lordship will find that there are three. Section 15, Your Lordship may kindly peruse for a moment, Your Lordship.
Yes.
Here, Your Lordship will find there are three parts. One is intent, another is means, and third is, Your Lordship, objects of to be achieved, Your Lordship, through by using the means. Your Lordship, if Your Lordship permits, may I read, Your Lordship? Whoever does any act which intend to threaten or likely to threaten the unity, integrity, security, economic security, or sovereignty of India, or which intend to strike terror or likely to strike terror in the people or any section of the people of India or in a foreign country, then, Your Lordship, the means by using bombs, dynamite, and other explosive substances, or inflammable substances, or firearms, or other lethal weapons, or poisonous or noxious gases, or other chemicals, or by any other substances, whether biological, radioactive, nuclear, or otherwise of a hazardous nature, or by any other means of whatever nature, or to cause, likely to cause, Your Lordship. And these are the, and first they have not, Your Lordship, then loss and damage or destruction of property, disruption of any supplies of services essential to the life and community in or in foreign country, or damage to, this will not come, Your Lordship. This, Your Lordship. Now, three factors will have to be present at the same time, Your Lordship. Only then, Your Lordship, section 15, an act can be called, will come within the ambit of, Your Lordship, section 15, Your Lordship. Intent will have to be there. The means mentioned in this particular section will have to be there, and consequences will have to be there, Your Lordship. If all three are present, Your Lordship, only then 15 will come. And in my humble submission, Your Lordship, going by the materials placed before this honorable court, also before the honorable trial court, Your Lordship, these three are not there, Your Lordship. At least intent, what is the intent, Your Lordship? Intent was on the face of it, is the against the particular law, which most of the people, Your Lordship, of the state think that it will be detrimental to the interest of the state. Opposing a particular legislation, Your Lordship, cannot come within the ambit of threatening the unity and integrity of the country, Your Lordship. Therefore, in absence of that, Your Lordship, section 15 will not be attractive, Your Lordship. And the nature of the, Your Lordship, by whatever nature means, Your Lordship, by using that particular word, Your Lordship, by whatever means, Your Lordship.
But was the meeting restricted to a simple meeting?
It was, Your Lordship, it
It was
was,
not a simple meeting or protest meeting. The situation was so dangerous.
Lords,
One police officer, he had to be in office for 3 days because the reliever could not come out of danger because of danger.
Lordship, that is,
That was
but
the
Your
situation.
Lordship, that is not on 9th, Your Lordship.
Understood, but that 9th has started, had
9th
triggered,
has started, Your Lordship.
triggered on 9th.
9th it has.
We are confining our discussion to 9th.
9th, Your Lordship.
But see the consequence. 2 days, one reliever could not even reach the police station. What to talk about ordinary normal citizen?
Lordship will kindly see, Your Lordship, that for that, Your Lordship, they will have to link this man, Your Lordship, with those activities, Your Lordship. And how they are trying to link, Your Lordship, that's the point. And Your Lordship will kindly see, Honorable Your Lordship, trial court, Your Lordship, while considering the cases, very clearly pointed out that the statement, the address of the accused person may be slightly aggressive in nature, maybe, Your Lordship, that is aggressiveness. If you go through that, it looks like, and but, Your Lordship, that will probably cannot be said that it is he has instigated people to violence. That is not there, Your Lordship. When instigation to violence on his part is absent, Your Lordship, then probably we
So
cannot.
whatever, there's a very thin line. What is instigation? What is not instigation?
No, Your Lordship.
It's a very thin line. For you it may be a very simple speech.
Your Lordship.
For somebody, it may be an instigation.
No, your Lordship.
So from that context, and vis-a-vis the framing of charges, we are not saying that you are guilty.
No, no,
That
that's there.
that stage has not even come.
Lordship.
Can we preempt? That is the consideration. What is the law for framing of charge?
Lordship, that is
Regarding that, there has to be a prima facie satisfaction.
Prima-
Nothing more than that.
Lordship, prima facie satisfaction with a rider, your Lordship. There will have to be a grave suspicion, your Lordship. What the normal suspicion? If there is a
See,
case,
prima facie satisfaction has to be connected with grave suspicion.
Lordship.
And where do you get grave suspicion? It is from the materials on record.
Lordship,
If only on two circumstances,
Lordship.
if there are no materials at all, or if the prosecution is backed by mala fide.
Lordship.
Now, mala fide is very difficult at this stage to
Lordship.
bring in. So we are mainly on the aspect whether there are materials or not.
Lordship.
Now, its materials means quality, not because 42 witnesses have given 161 statements, so materials are there. We are making a scrutiny of a prima facie scrutiny. What is the quality of the statements recorded?
Lordship.
And these are not evidence, 161.
Lordship.
But based on this, the charge sheet has been laid, and on that, there was a move to have the charges framed, and you argued charges cannot be framed, so your argument has been accepted by the court, which is the subject matter of challenge.
Lordship.
Now we were under legality of that order, whether there are materials in spite of which the charges have not been proved.
Yes, your Lordship. And my humble submission before this honorable court is that, your Lordship, accept these statements on its face. Even then, your Lordship, terrorist act will not come. That is my humble, and that has been rightly held by the honorable trial court, your Lordship. Now, your Lordship, in absence of the intent, in absence of the means, and in absence of the consequences on 10th, 11th, 13th will not come. Consequences on 9th. A sporadic incident or incident.
No, he has not argued on 10th, 11th.
Lord, that is why.
He has not
A
argued.
sporadic
And we are also
incident-
not going on.
A sporadic incident of rail roko, your Lordship, on 9th, which has been.
It's not a sporadic incident.
No, on 9th.
Calling for an hesitation, then this kind of violence, not sporadic. Sporadic means something else,
No, your Lordship.
out of chance.
Kindly see, your Lordship. Your Lordship will kindly see. So far as the rail rokos and other kind of agitational programs are there, your Lordship, these are normally, your Lordship, takes place in our country, your Lordship. No one is put behind under your UAPA for those incidents, your Lordship. But these are normal incidents. Now, your Lordship may kindly come.
The learned trial court has gone much ahead.
No, your
Not
Lordship,
only UAPA, nothing is applicable. No materials.
no material so far as UAPA is concerned.
Even
That's-
others,
No, others-
discharged.
Your Lordship, others, your Lordship, that's a different matter, your Lordship. There may be certain, your Lordship, so far as other sections are concerned, your Lordship, but UAPA is a stringent provision. While interpreting UAPA, your Lordship, your Lordships will have to panel statute, and that too a statute like UAPA, your Lordship, will have to be strictly construed. That has rightly been done by the honorable trial court, your Lordship. And that's the law, your Lordship. All penal statutes should have to be strictly construed. And when it comes to a statute like UAPA with stringent conditions, your Lordship, it will have to be more. And your Lordship will have seen the prima facie satisfactions required as it has been held by the honorable trial court, your Lordship. Prima facie satisfaction, your Lordship, the nature of standard of satisfaction will have to be higher than the granting of bail when framing of charge. Going by all these, your Lordship, if we look at the materials placed before this honorable court by the prosecution, your Lordship, under no circumstances, your Lordship, one UAPA sections of 16 will not come. And interestingly, your Lordship will kindly see this FIR as well as the statement of the informant are part of the Sanmari case, your Lordship. They are also taking into account this speech, the FIRs, the injury reports in Chavua case, in the Sanmari case, where your Lordship and I has already submitted charge sheet, and this case is also, charge has been framed, your Lordship. Now we have put that to challenge, your Lordship. In all these matters are there, your Lordship. In that particular case, your Lordship, the accused is not charged under section 16. In that particular case, your lordship, accused is charged under section 18. That is, no terrorist act had taken place, but conspiracy has taken place. Now, that is the contradiction, your lordship. In one case, with the same materials.
How can it be same materials? The incidents are different.
No, your lordship, incidents are different, but this is part. Now, your lordship.
Incidents are different. It will depend on what has happened on that particular
No,
day.
your lordship will kindly
We are examining the case which has been registered in at Chabua, pertaining to the incident at Chabua on 9th.
That is what, your lordship. These incidents, your lordship, these FIR, your lordship, part of the investigation in the Chanmari case, your lordship. Now, in spite of that, they have charged him under section 18. It's a conspiracy. Now, here they have charged him under section 16, commission of a terrorist act, your lordship. Is it not contradictory, your lordship? Then when you have taken cognizance of a particular case based on which a separate investigation is going on, and you have made it part of your investigation.
From where are you making this submission? From where are you making this submission? This
No, your
Chanmari?
lordship, this is connected to the
No.
other case, your lordship.
See, those are not before us. How can you appreciate this kind of submission?
I just pointed out. Your
No, if you think you can develop a case, those materials have to be before us. We are examining that.
These are,
order.
your lordship, somehow, your lordship, these are part of our argument also in the before the honorable trial court, your lordship, NIA court, your lordship, but somehow this has not been reflected. That's
Those are not before us.
This is not there. But in the other case, your lordship, is
From any material, if on record, if you can
in
develop
this
a case,
particular case, your lordship, it is not.
then difficult.
But the point is what I am
You may
trying
be
to
factually correct, but for how do you appreciate
now,
this?
lordship will ultimately, your lordship is considering a case, your lordship, where a person will have to, 4 persons will have to face, your lordship, the trial. And the UAPA trial, as your lordship knows, it's a very this stringent law, and it is.
Mr. Botaku will not be influenced by those. If materials are there, whoever he is, he'll have to face.
No, I am
if
not,
materials are not there, that's a matter will be different. Only because the offense is stringent, the so-and-so is stringent, that's not a ground at all. You make out a case that materials are not there.
No, that is what my case is all about, your lordship, and that's why, your lordship, I am trying to show, your lordship, the act, your lordship, provision of the act. As well as now, your lordship may kindly come to the speech, your lordship.
Is there any transcript?
Yes, they
Yes.
have annexed, your lordship.
Yes. Where? Which volume?
Deed of 29, your lordship, document 29, volume 1.
Volume 1.
Yes.
Page?
Page 273. Document 29. 273.
It's a video.
Speech, your lordship. May I read it?
Yes.
Today, the villagers from CM's constituency, Sabwa, came out in highway. People from CM's family came out in highway, and very clearly tell by the people of Sabwa that we don't accept that. When CM tell in that they is a very good thing and to implement the expresses the at this moment, I think he is taking a position in opposite pole of people of Sabwa say that when CM is done. Being native of the area, they feel same, and there is no other option left to support. I think today the people of Sabah is an example for comparison because in 2016 when Tech came, there was a large case in Sabah, large number of people came to Sabah. This time in 2019, also 10,000 people came out on the highway. And tell clearly that we do not accept that means by sitting in the power of 6 has given up patriotism. But people from his area, people from his place, people from his neighboring was that we will not do patriotism. We have to save our community, we will not be able to alone in the hand of foreign. Therefore, I can say I think so is the most able position in someone who's best person. Therefore, I don't want to reply for reversing the municipal person. If he wants to see the movement, I wanted to invite him and said, well, I wanted to invite him once earlier that particular city persons come to support to see the movement by wearing color plus of the and women to get the seat of CM, what kind of speech you deliver. Australia, Assamese community, therefore, to show you so and so has been identified as modern loan with one person is people who calls once called me once you have covered and suddenly has called so much of a if art is already on it comes selects. Then in next page 275, another part will also. My brothers and my sisters, these people from Sabua become example for Assam. Therefore, I request all of my volunteers create one human chain from side by holding each other's and create another human chain on that side, and no one will go out from the past even without asking the volunteers. For example, you have shown Assam person organizations could not plan together in everywhere in Assam, but here in Sabua. You see in Sabua, the community of Asu is here, also the community of PNS is present with the Asu. And the Assam that Sabua has proposed need to be all other residents organizations of Assam and each and every Assam person need to unify and make this movement successful and reality for success of our these are of community unified. Yes or no, they are from this back for everybody. Now this is the statement yours. Now these are in this statement he has not called for violence. He has not called for your lordship rail roko. He has not called for economic blockade, your lordship. Nothing is there, your lordship. Now, this is a statement relied on by the speech, relied on by them, your lordship. Now, they are witnesses. If someone is saying, your lordship, that contradicts their own material, your lordship. Yes, your lordship. This, the very fulcrum of their argument is, your lordship, is this piece, the prosecution case, your lordship. That this speech, provocative speech, this has resulted in the violence. Now, where is the call for violence? Even he has said that you create a human chain and don't go out of that particular human chain without asking the volunteers. And if your lordship see the statement of the PWA, your lordship, what he says, your lordship, this statement prima facie not true, your lordship. What he has stated, your lordship. However, so and so addressed the meeting during his speech. So and so provoked the people and asked them to oppose the government using any means, whether they had to do anything for it. It is prima facie not there in their speech. They have brought on record, your lordship. And in fact, your lordship, the rail roko, if your lordship go through the statement of the railway officer, your lordship will find before my arrival, your lordship, accused number one's arrival, your lordship, this rail roko was going on, your lordship, from 4. He arrived at 6, your lordship, as per the materials placed by them, your lordship. Therefore, your lordship, in none of the cases, your lordship, there is no material to link the petitioner with the accused petitioner with the petitioner number 1 with the actions that have shown to be, your lordship, offensive act on the part of the persons concerned. And your lordship will kindly see that if had it been a case, your lordship, the meeting has been organized by these 4 persons, your lordship, by alone, your lordship. He is the only speaker. And after that, there is some kind of incitement on his part, your lordship. Then, your lordship, violence started, your lordship. then matter would have been different, your lordship. Your lordship kindly come to the evidence of PW. Is your lordship PW 31, your lordship, at page 52.
$52.
52. May I read?
That
it?
DYFI.
I am above mentioned on being asked, I state that by profession I am a businessman. I am a Dhubagad District Secretary of UAPA. In the year 2018, in the month of October, November, one meeting was organized in Sabua, where almost 70 different organizations from different communities, local club, disease organization, etc. of Sabua area comes under one umbrella organization called Nagorikotto Samshodhani Bidhayok 2016 Biruti Moncho to fight against CAP together. AMSS leader so and so, so and so, and so and so, and some other prominent leaders of various organizations who were present there. I was also present there on behalf of DOF. Now, your lordship, there are several other persons who present who participated in this particular meeting, your lordship. Then, on being asked, I further state that unlike other organizations under this umbrella, our organization also took part in various protest program in different places. But when CAB about to pass at Rajya Sabha, the movement became more intensified from October 2019. Various organizations, including our organization under umbrella Nagorikotto Samshodhan Birodhi Moncho 2000, planning for various protest program, including Rail Roko protest march. It is your lordship not by his call. They themselves has organized this Rail Roko protest march, meeting, etc. Accordingly, on 9/12/2019, people from local areas start gathering at near Sabua railway station and market area at around 5:40 to 6 p.m. Different leaders from various organizations like ATSA, AJYCP, KMSS, etc. began to deliver their lecture regarding protest against CAB, where KMSS leader so and others, your lordship will see, also delivered aggressive and provocative speech. In the program, larger number of people came out voluntarily, your lordship. In that meeting place, due to which road traffic was disrupted, but I along with other organizations tried to clear highways, but our program was to rail repo, so we blocked the railway block. Now, if your lordship will kindly see on the face of this statement, is he not should not have been arraigned as an accused, this witness? He himself admitted that we organized the rail repo. So we blocked the railway track. In spite of this admission on the part of this witness, he has not been, your lordship, arraigned as an accused, your lordship. Why? No one from our organization and other organization working under the umbrella of so and so took prior permission for district authority to conduct any public meeting of protest in Sabua area on 9/12/2019. When the program was going on, I have heard that one CRPF vehicle was damaged and OC Sabua was attacked and caused serious injury by some miscreants some distances from the program place towards the India side. At that time, I was present in program place. I have not seen the above incident personally. After that situation become more tense and per advice of SCDC, I, Devotee and other concluded the program at around 8 p.m. Now, on the face of this statement, your lordship, I cannot even be blamed for the rail repo, your lordship. And if your lordship go through travel through the statements of the persons, your lordship, with so far as the other three accused persons are concerned, your lordship, what are the materials against them? Except one saying that one Sorgojuti, your lordship, at that time I saw Bhupan Bhaskar, Jagjit Singh were along with other protesters near damaged vehicle while I tried to remove the burning tire from the Sorgaditya Pukon hit on tire with a sword. Except that, your lordship, there is no material at all against these three accused persons, your lordship. Accused number one can be, your lordship, they have at least started investigation, your lordship. They have the power, your lordship, since he made some speeches. He's a leader, your lordship. But the others, your lordship, there is no material at all against these other three accused persons, your lordship. The similar line of statement by PW 30 also, your lordship, that this was organized by them, your lordship. Your lordship may kindly come to this statement of your lordship, Vishwajit Phupon, PW 10, PW 18, your lordship, page 32. Questions put to him, your lordship. Three questions, your lordship. Who took the lead of gathering of so many crowd at the venue? I think it was the organizer, including KMSS, who gathered so many public there. It should be their responsibility to make the environment peaceful. At least Okil could have managed the situation as he was the only guest lecturer there. Your lordship, could have managed the situation is one thing, your lordship, and the provoking people to or inciting people to do violence is another thing. Your lordship. One thing is different. It may be morally reprehensible, your lordship, that I, in spite of seeing that people are violating, I did not, your lordship, object to that. And secondly, your lordship, so what was the gist of the speech of Okil Gogoi at the meeting? It was against government. He warned people against the probable infiltration of Bangladeshis into Assam and asked all to intensify the protests. That's all, your lordship. And thirdly, did Okil request the crowd not to vandalize? I did not see. Now, can this be incriminating, your lordship, in any manner, your lordship? Question should have been, your lordship, whether Okil Gogoi has provoked the people to do violence. That question has not formed in that manner, your lordship. Question is formed in such a manner that did Okil request, as if not asking to vandalize, your lordship, it cannot be an offense, your lordship. Ideally, your lordship, if he has, even assuming he has not asked, your lordship, that cannot be an offense, your lordship. Telephone conversation. Your losses may also go through the telephonic conversation, your lordship. That is the transcript that starts from 201.
201.
201, your lordship. Your lordship will find there, your lordship, in this, nowhere, your lordship, there is any talk about, your lordship, violence, your lordship. It's all about the protest, your lordship. It's- one telephonic conversation, two or three telephonic conversations, they relied on, your lordship, That is with one Sanjay, that is your lordship, Sanjay Jha was a Rajya Sabha member, your lordship. He coordinated with him for your lordship for protesting it in the parliament, your lordship, while this bill is brought, your lordship. That is what, that cannot be an offense, your lordship. Your lordship will kindly see, had this been a coordinated effort, your lordship, by him, your lordship, page 207 for a moment, your lordship. He is talking with one Paramananda, your lordship.
Page?
Page 207, your lordship. It will show that your lordship, this entire protest, your lordship, it is a spontaneous protest, your lordship, rather than an organized protest, your lordship. Different organizations, different people are there, your lordship. On 9th December, Monday, target, yes, Parama tell me, on 9th December, Monday at 9 AM, we will gather in front of DCF Jorhat, not on banner of a particular organization, but as Jorhat citizens, we want to show how it is when each and everyone comes out to protest. He says, okay. Everyone told me Rajiv Gogoi Atasu was there. Little will be joining for the program, and if you will be there nearby Golaghat. Actually, promised to go to Sabua, cancelling all other programs. Sabua, they are planning to take a big program at Sabua. Ask Target to talk with Rajiv Gogoi. Tell me, Rajiv, Dada, be in your program, in our program, and how as it will be at 9 AM. As it is a bond on that day, so I already promised to go to Panitula at day and Sabua at night. At what time will you go? We'll go from Gauhati tomorrow as after that Assam bond. Someone might throw stone on me if I drive on that day. Who will be throw stones on your vehicle? People will not know me from far away. If you get in Jorhat, it would have been nice. It had, if I had known before, it would have attended it, but now it is not possible to have already promised them. If you organize again, then you will say, if you only attend, okay, okay. Your lordship will see that he himself is, your lordship, apprehensive of your lordship stone pelting by others, your lordship. Where is the question of he organizing such a thing, your lordship? And they have brought it in incriminating. And your lordship will kindly see one statement, your lordship. This has been shown by the prosecution during the trial before the to show the intent, your lordship, of the 220, your lordship. Now here your lordship will find he has only, your lordship, nodded, your lordship, rather than that there is nothing, your lordship. This is between he and another person, your lordship. Tell me, you small thing today in Proceeding Times, me and so sat together and told that Assamese people are not that foolish, what they think of them and who is that fellow. Is it so and so and so and so who is delivering chaotic speeches about Cape to Assamese people? Tell about these things. He says, okay, sure. I called you to give an idea that as a Japan Prime Minister Shizo Ibe will be coming 15th December. So if it is possible to post 10,000 posters in Gauhati where should be written Shizo Abe most welcome to Assam, but Narendra Modi go back Assam, then an international news will be delivered. If this bill passes, then there is no other option than going to Supreme Court. Even if the bill passes in Rajya Sabha, the Andolan will go on. Okay, sure. Now, this has been shown as your lordship on before the honorable trial court, your lordship, the intent, your lordship, to defend the country before that. But he has not proposed, your lordship. He only says, okay. It was proposal from other side, your lordship. Now, based on these kind of materials, your lordship, can your lordship, a person be, your lordship, brought under a section 15, your lordship? And even the otherwise also, your lordship, by any other means, your lordship, the words, we will have to interpret the, your lordship.
See, just out of context, 220, you are on 220.
Lordship.
See the date and the time.
Lordship.
Time, what is the time? Time
Lordship.
is 10:27 p.m.
Lordship.
You are trying to rely on this to make out a case to wriggle out. But this may not be relevant at all. This is post the incident.
No, that is, no, you're.
If you are
why-
sketching that the next incidents cannot be taken into consideration, this is post.
No, you're, why
Then
I
no
am
problem.
trying to point out, your lordship, before the honorable trial court, this was your lordship reliance. That's why, your lordship, I am trying to point out that to show that intent, what was the intent? That is why I have pointed this out, your lordship, now, your lordship. And that is why these materials, they have brought, your lordship, it is their material, your lordship. Now, if your lordship takes up the judgment, your lordship, there is para 45. I will pray before this honorable court, your lordship. I have some then judgment to submit, but today I.
No, no, we'll grant you, don't worry.
Lords,
We are not concluding today.
lords,
We'll hear Mr. Saikia,
lords,
and we'll thereafter you'll have a chance at another chance. But substantially, you want to complete the factual part
lords,
and your arguments so that because this is an assigned bench, we want to complete this matter.
para 45 onwards, your lordship.
Page
135,
135.
lords. May I read, your lordship, this?
Just a minute. 135. Yes, analysis.
Lords, analysis. Amongst the witnesses examined by the police during investigation, I find that protected witness A and witness number 2, 3, 17, 18, 13 are some of the eyewitness to the alleged incident. All these witnesses have stated that on 9/12/2019 in the evening, there was a large gathering at Sabua near Sabua railway station, which was also addressed by A1, and that he gave provocative speeches there, and subsequently the crowd turned violent and started pelting stones, one of which hit the witness number 2, so and so, grievously injuring his face and throat. The nature of injuries sustained by the informant is clear from the medical evidence on record, and the statement of witness number 19, Dr. C.R. Joshi, a dental surgeon at Dibrugad. The witnesses have not stated that A1 has directly incited the violence. Your lordship will kindly note that, your lordship. Incited the violence, but they have stated that he delivered provocative speech, where after the crowd turned violent. Protected witness A has also stated that after the crowd turned violent, A1 did not denounce it or did anything to stop it. Witness number 2, informant cum victim, has also stated that when after sustaining injuries, he was being shifted away from the site, he was on still addressing the gathering. In his statement, witness 18, Vishwajit upon a TV journalist stated that after vandalism, A1 and others remained at the site for an hour, and that this witness did not see A1 requesting the crowd not to vandalize. Witnesses like witness number 5 and 8 have stated that the crowd led by Akhil Gogoi started pelting stones in the police party. But some of the other witnesses have stated that Akhil Gogoi delivered an aggressive or provocative speech, and subsequently some members of the crowd started pelting stones in the police party. Therefore, I find some differences in the nature of incident narrated by the two sets of witnesses. Further, several of the witnesses have stated that they could not recognize the protesters who had thrown stones on the police party, leading to injuries on the OC Sabua police station. There is a clear finding, after going through the material placed by them. The statement of witnesses of so and so was that accused persons, including A, was gathering, leading the mobs, is not corroborated by similar statements on the part of the other witnesses about the accused person leading to mobs. Further, some of the witnesses attributed vandalism on the part of the protesters instead of attributing it to A1. Some of the witnesses have also stated that they do not know the attacking persons, and some other witnesses have also stated that they could not recognize the attacking protesters in the dark. Some witnesses have simply stated that some protesters in the crowd pelted stones. In the context of statements of few witnesses that A1 gave a provocative speech to the crowd, which turned violent, the contents of the speech available in document D29 is most important to correlate the two. In this regard, upon perusing the speeches of A1 from D29, I find Though it contains some sharp political statements and criticism with regard to CAP, there is no incitement to violence. I also do not find in incitement instigation to damage property or obstruct public officials. Considering the content of the speeches available in D29 and the statement of the witnesses about provocative speech, it appears that the tone and tenor of the speech might have been aggressive on the issue of car rather than the speech directly inciting violence. After noticing the contents of A1 from D29, I find a contradiction with the statement of one or two witnesses about A1 leading violent moves, throwing stones. If the contents of the speech of A1 do not contain instigation of violence, etc., simply the statements by some of the witnesses about A1 giving provocative speech leading to violence could not be relied on in my considered view to impose criminal liability on A1. In the large gathering where speeches were delivered on contentious issues, it is possible for the crowd to get excited and some unruly elements therein might take undue advantage of the situation to indulge in unacceptable behavior. The omission on the part of the A1 is revealed by the statement of some witnesses is that after some vandalism started, he did not do anything to stop. However, in my considered view, that in itself would not impose criminal liabilities on him, though it might have been his moral responsibility to try and do something about this. Your Lordship. It's a finding, Your Lordship. It's a reasonable finding given by the Honorable Court.
The findings appears to be given in a trial after a full-fledged trial.
No, Your Lordship, that is not, Your Lordship.
That is where we are concerned.
No, Your Lordship.
These can be consideration in a trial, whether an allegation is proved beyond all reasonable doubt. There are two views. Now, it's only at the stage of framing of charges. From that to context, we are trying to examine.
No, Your Lordship will kindly see, even if Your Lordship.
It was on a very threshold examination, whether you proceed or not.
Lordship, it was threshold.
Threshold examination.
Threshold. And Your
And
Lordship.
threshold, what you require to see? These are not even evidence.
No, that is why, Your Lord.
Whether materials are there to go ahead.
That is there. But in my
If there are no materials, absolutely it's an abuse of the process, will discharge you. But if there are materials,
definitely, Your Lordship, if there is material-
can we preempt a trial? Can you obstruct the prosecution even from a chance to prove that allegation?
No, Your Lordship, that is not there. Your Lordship. But Your Lordship, on the face of the materials, Your Lordship, on the face of the materials, Your Lordship, prima facie, whether I can be linked with violence or not, that is the point, Your Lordship. Prima facie, Your Lordship. Where are the materials, Your Lordship? 9, post 9, Your Lordship, 10, 11, 12, we have given up, Your Lordship. Only remains 9, Your Lordship. My speech does not call for violence, does not incite people to do violence, Your Lordship. And then, Your Lordship, their own witness is saying that rail roko is declared by us. We have participated in the rail roko. Their witness, Your Lordship. Then where is the material to link me with these activities, Your Lordship? And witness is saying that every witness, Your Lordship, their statement is that I give that provocative speech and they themselves had it not been brought to the record, matter would have been different, Your Lordship. When the prosecution brought this into record, Your Lordship, can this Honorable Court refuse to take cognizance of that speech, Your Lordship, which is the fulcrum of their allegation, Your Lordship? If speech should not have been there, then matter would have been different. They themselves has brought on record, Your Lordship, claiming it to be an incriminating speech. And Your Lordship will have to ultimately test the statement of the witnesses vis-a-vis this particular speech, Your Lordship. And going by that, Your Lordship, in my humble submission, there is no material. That too, when we look at the provision of section 15 of the Unlawful Activities Regulation. I am not talking about other sections, Your Lordship, of the Indian Penal Code, Your Lordship. But so far as the UAPA is concerned, there is no material at all, Your Lordship, to bring these 4 persons within its ambit, Your Lordship. An incident of rail roko on its own cannot constitute, Your Lordship, that too for 4 hours, Your Lordship. That will have to be in such a manner, Your Lordship, that there is no possibility for 1 day, 2 day rails are not being going, Your Lordship, that people are gathering and stopping it. And these kind of movements are normal in this part of state, Your Lordship. from days of your lordship Assam movement, your lordship. These, your lordship, background probably in my humble submission, your lordship, we cannot overlook, your lordship. And so far as the other three accused persons are concerned, your lordship, there is no material except one statement on the part of that they are part of that protest, your lordship, and one by using a sword, your lordship, tried to, your lordship, cut a tire, your lordship. Then more than that, there is nothing, your lordship. More grave the charges, your lordship, more material will have to be placed before this honorable court by them, your lordship. Had it been a case of 326, maybe again matter would have been different, your lordship. You are trying to charge something with the with anti-national activities, your lordship. Grave charge, your lordship. Consequences are grave, your lordship. Then you will have to bring certain materials which can satisfy the consents of the honorable court, your lordship. An honorable trial court, your lordship, in my humble submission, your lordship, so far as this materials are concerned, your lordship, maybe, your lordship, that honorable trial court has gone somehow analyzing the materials has slightly gone beyond the permissible limit, your lordship, maybe, your lordship. But ultimately, ultimate finding of the honorable trial court is, your lordship, we have to see, your lordship, is done. And to a certain degree, your lordship, that will have to be tested, sift and weigh. Honorable Apex Court has said, your lordship. That will have to be done by the trial court, your lordship. It is not that by closing the eyes, your lordship, the honorable court will accept the material placed by the prosecution, your lordship. Some kind of, your lordship, analysis, that's not be, your lordship, inquiry like the trial, your lordship, but sifting and weighing of the evidences, your lordship, and all the courts will have to do, your lordship. And in my humble submission, if you do that, your lordship, probably with utmost humility in command, your lordship, I am submitting, your lordship, that this is not a case for, your lordship, UAPA, section 16. If your lordship permits me to advance my rest of the arguments another day. In fact, your lordship, I have not prepared, your lordship, since, your lordship, I thought that.
No, it was the case was for final disposal.
No, your lordship.
We are not adjourning this now. You know, we made it very clear last time.
That is why I did not did not bring the judgments to that.
What the proof is a fine matter. Yes, Mr. Google.
On 17 losses, 17 or 18 losses. 17 or 18.
Your also may fix it on 18 months.
We have no difficult losses on 18 losses. We have no difficult on 18 losses.
18.
18 losses.
18 we can have.
Losses.
Parenting a good bird.
Thursday or something. Thursday. Probably lawsuit 18 is the Wednesday lawsuit.
Doesn't matter, division bench.
Lordship, Lordship, Lordship,
We'll sit at 10:30 itself.
Lordship, Lordship, Lordship.
Hearts brief, K. Gogoi, learned counsel for the appellants. Also heard, the airport for learned counsel for the respondents. Full stop. The matter has been substantially heard and heard to Satri Gogoi, learned counsel has made a request for some accommodation to enable accommodation so that Sri D. Sekar, learned senior counsel, can make the concluding arguments.
Lordship, Lordship.
Full stop. As agreed to by the learned counsel for the parties. List on 18.
18, Lordship. Always, Lordship.
Okay. Single bench one, sir. You just want to hold up, that's in the body. No? Kuntu. What I ordered? Connected, all matters are connected. India, what are the other matters?
Those are your lordship in summary case of lordship. That charge was framed.
Again,
First charge was discharged, we are discharged, then came to dishonorable court, then remanded back the matter, then next charge was framed, that we have to proceed.
You have challenged. Oh, you are the appellants in those
Not
cases.
apparently criminal revision.
Okay, petitioners. Okay, then you write this in the first case and rest, list. So those you need to, we need to hear you separately. Arguments will be different in this.
Slightly different.
The party may be the same,
Will be different.
party may be the same, but
Party
the
is same, but
the entire argument will be different.
Lordship, Lordship.
And result of this is not going to,
not to affect that.
Lordship, Lordship.
those we need to say, decide separately.
Lordship.
Please tell them. The single bench will sit for some time, but no long matters. Okay, we'll just within 10 minutes we'll sit.
Always, Lordship.
Motion. Urgent. We'll have it tomorrow motion. What is your name? On a request made by Sri K. Islam Learned Counsel for the petitioners, matters are adjourned to be listed on 1 week. We will list. Today is 26th. We'll have it on 9th of March. 9th of March. 11 and 12. That I ordered, 9 March. Other side are informed? No. What is this, Mr. Islam? There are other AEGCL is there. What is this kind of practice? Whole day you are there, not informed. No, don't write. Don't make a mention without informing. This is not something new, Mr. Islam. You place yourself on the other side. We'll make an item mention and we'll make you wait till 4:30 in the evening. It's your headache. From where you get the number. I will not do. You have to inform first, then make a mention. Yes. When? What is the urgency? Is Monday we can have. Tomorrow is there an urgency? We can have tomorrow. Other is Monday. Have you filed or not?
I didn't want.
Yes, madam, what is this? Mr. Sharma, what is this? You are supposed to have the instructions.
Lordship, I have received. এখন দিবস। Step is taken, has been taken now. Yesterday, the letter is issued to the officer in charge, Borsuk Police Station.
Mhm. On 6 March.
25th.
No,
Sorry,
no, 6 March is
Yes.
the date.
on 6th.
Madam, there is a warrant of attachment issued by the district commissioner on 25th of February, whereby the warrant has been directed to be returned on or before 6th of March. We can have this matter after 6th of March, okay? No, this is there, let us
It
see.
has already been
No.
initiated.
Here there is a command for returning the warrant, okay? What is your name? Madam, your name? Heard Miss S. Patori, Learned Counsel for the petitioners. Para. Sri H. Sharma, Learned State Council, has placed before this court copy of a warrant of attachment of immovable property issued dated 25/2/2026, issued by the District Commissioner Kamrup M, whereby the date has been fixed on 6th of March 2026. What's the para? In view of the aforesaid development, consideration of this matter is deferred, and the same is directed to be listed on 11th of March. Yes, the communication dated 25/2/2026, not communication. The warrant of attachment, a copy of the warrant of attachment dated 21st is kept with the records. On the next date fixed, comma, Sri Sharma, the Learned State Council, would obtain the up-to-date instructions. Up-to-date means update. Yes. Two.
Please, your lordship, they file the counter, we have to file the reply, my lord. Sometimes may be required. And another thing, your lordship was please.
He is the applicant for vacation of the interim order. Then,
That was heard on last occasion,
okay,
and ultimately the order is there. I think.
in the IA,
Yes, yes.
stay has not been vacated.
No. The order is in the nature.
So he has filed counter in the writ petition.
Yes,
You want to file rejoinder.
yes.
That means we are not considering this IA, we are considering the writ petition.
Writ petition.
Mr. Ali?
Because over here, the issue. No, over here, hard to get.
If you are agreeing that the writ petition can be heard instead of focusing on the IA, then we'll allow Mr. Abedin to file the rejoinder and have this writ petition. There are writ petitions connected or what? What about the other writ petitions? Connected, all connected.
All connected. Actually, they filed initially, they filed the writ petition against my election, saying that I should not have been elected, I disqualified. So ultimately, while the case was pending, I was disqualified. So otherwise the matter has become infructuous as far as their petition is concerned. I challenge that, and that is the case, my lord. So both the
Okay.
cases are tagged.
Okay. You have an interim order.
Yes, I have been from my lord only.
So this court is the best court to vacate the interim order, which we will do now.
Yes, ma'am. But only thing is that on last occasion, the
Since you have said that this court has granted the interim order, so we have all the authority to vacate it. Question of propriety will also not be there. No moral propriety involved.
Possibly, my lord.
I've done an error, will recall the error.
Not an error exactly, well. My lord, over here, the issue raised in the present petition is presently pending before the apex court in Jahanara Begum versus so-and-so. Nevertheless, it will require some examination as to the contentions raised by both the parties before the court regarding applicability of the amended provisions of the Assam Panchayat Constitution rules. Accordingly, fix the matter so-and-so. The parties are at liberty to apprise the court as to any such order that may be passed by the apex court in the meantime. The parties are also permitted to exchange their pleadings in the matter. So after that, they file the affidavit in opposition, that is the counter. Now I'll file the affidavit in reply.
Okay.
And in the meantime, I've got the
Okay.
information, my lord, the tentative date is 24/3 before the apex court.
Yes, my lord. This is the on 18 matter. And then that petition, my lord, has been number 4, my lord, there are more than 3 signatures. And that case, my lord, the present petitioner, my lord, he also the party, the petitioner, and the address for the person who approach the person who also part, all the cases dismissed, my lord. After, my lord, the division of the IMI for 961 days delay. So delay was dismissed at the same time it was dismissed. And this of the address code matter. The address code only for the delay one school that are after something. That is 18 matters, 18 times. Now that matter is not. And the insurance 500. Initially, suddenly order because my lord there that time my lord that petition my lord was more than 8 cylinder. And that was 2018 when he was elected as month. And this
More than 8 means how many?
8, say more than 8.
Oh, 8. If you say more than 8, it can be many more.
More than 8.
8.
8 So they approach.
How do you know all our sons? How do you know all our sons? No daughter.
So my lord, that order was 7 people. That is simple. Thereafter, my lord, the whole deputy courts of the party speaking order.
Now they are aggrieved.
No, my lord. They are submitting all the fact, my lord. They approach my lord.
No. No. Only one thing, that is bad.
Have you stated?
Caveator was hard when the.
No. Have you stated this in your affidavit in opposition? Okay. Then you find your rejoinder. Okay. Heard Sri J. Abidin, learned counsel for the writ petitioner. Also heard Sri N. Das, learned state counsel, as well as Sri semicolon Sri S. Datta, learned standing counsel PNRD, and Miss Kayasta, learned counsel for the State Election Commission. Full stop. Sri H. Ali, learned counsel, is present for the contesting private respondent who has filed affidavit in opposition. Full stop. Sri Abidin, the learned counsel for the petitioner, prays for some time to enable him to file the rejoinder affidavit. List on. We'll fix a date after 26 March. Because again, same thing they'll say. Matter is there on 26th.
Let it be on.
We can have it earlier also, 24th, but doesn't matter. We'll have it on 30 March. 30 March, Monday. Okay, Mr. Ali?
30. Yes, madam.
30.
Okay.
Monday. Good, sir. Affidavit filed, further pleadings filed in the meantime be tagged with the records. Interim order passed earlier to continue till the next day of listing. It will hit the This you will write in 6284.
46. I do 46.
What are these matters?
Also, there the persons who are living in a destitute house, Lordship at Kachar Silchar, they are from the East Pakistan, coming prior to 1958. So now they are claiming that they should be rehabilitated there, and certain misappropriation of money, government fund is there. Accordingly, they are also asking for CID or investigation. So this is the case, but regarding the first part, most probably Lordship, the this honorable court has already passed an order in WPC 811/2008. And regarding the second part, they have not lost any affair.
But they are not
Yes, Lordship,
appearing.
they are not there.
Even last time they had not appeared. None appears for the petitioners on call, whereas we each Sharma Learned State Council. Mr. Chakraborty for?
Next two, not connected to the first.
Next two items are for the
Different. I don't know how this matter has got.
but same petitioner.
The petitioners perhaps are same, but
What is the cause of action there?
second petition that has been filed might not be on a different footing. These petitioners have come up before this honorable court alleging respondent number 9 to be carrying out certain construction works within that city home premises. I am appearing for respondent number 9.
So let us do one thing. So for the 16 is concerned, we dismiss for default.
Right.
And second, we'll give a further chance. Okay.
There is an increase.
Okay. First 4 to Likhiba. None appears for the whereas are you appearing, madam? No, in 4. 4 revenue is the party? No. Even on the last occasion, there was no representation on behalf of the petitioners, Para. It appears that the petitioners have lost interest in this case, which is pending since the year 2016. Mr. Para. Accordingly, the petition is dismissed for non-prosecution. And in the two item, Bakitra Rekiba, none appears for the petitioners in this case, in these two cases. However, Miss, you appear for, madam? Who is one? It's a contempt petition. Whereas the respondent number 1, whereas the respondents are represented by Miss K. Fukan, Miss G. Hazarika, Air for Revenue Department, and Sri S. Chakraborty for
In petition for respondent number 9 and in the contempt for respondent number 4.
Para. Be that as it may, to give and in the interest of justice, let another opportunity be granted to the petitioners to represent. Para. List on Monday next.
There is an interim in my favor, madam.
Para interim order passed earlier, if any, stands extended till the next day of listing. Each Sharma likhi very good. 4 to dismiss or default. Are you again? Last one. লিখিবা ষ্টকৰ কাছে আছে নৰ্মেলি লিখি থৈ দিব ৰেচপণ্ডেণ্ট নাম লিখিব এইচ শৰ্মা লিখিব প্লিজ ডোন্ট পিক ৰেচপণ্ডেণ্ট নেম তেতিয়া কমন হৈ থাকিব নৰ্মেলি জেনেৰেল য়েছ নেক্সট What is the matter?
The legislative matter, they have even top payment of work which are also successfully completed. Even completion certificates are issued. Even then, those payments of those particular works have not been. given to
Public Works Department.
public works.
Yes, Mr. Bhuya?
Lordship, regarding these matters, they have just been allotted to us today. I would require some time, Lordship, to go through the materials so that. we
But
can-
these are old matters, Mr. Today, because maybe because of paucity of time, otherwise we'll not entertain an accommodation, prayer for accommodation. These are old matters.
So besides, this is a demand sub matter also, if I'm not mistaken.
Who is for Dimasa?
These demands.
Then, Lord, we'll require some time.
No, even PWD is a transfer subject. They're considered, it has to be defended by Dimasa. Unless it is on the department. If the decision is not by the department, if it is by their officers, from additional chief engineer onwards, it's all under the Dimasa. Who's for Dimasa? Name sure or not? Mr. Borua? Okay.
Also, it's not a party here, my.
Hmm?
Demands are not a party because it is not a.
It's not a party here. Okay, okay.
Then, Lordship, we
Oh.
will.
If no, if no, we thought they were a party, if, okay. Heard three, A.K. Barua, Learned Counsel for the petitioner. Also heard three, and the Learned State Council, and three, M. Bhuya, Learned Counsel representing the Public Works Department, para. Paucity of time would not allow the matter to be taken up today, para. On request, list on, list for admission hearing on today is what? 26. We can have it on 10th, then on 17th. 17 March. Mr. Bhuya, 17 March, come prepared.
17 months, Lordship. Must be. Deadline.
Item number? Yes, what is this? Twenty-six. Is it connected with this? Why is it connected to my matter? Who are the petitioners here? No.
One Meena Kolita.
Ina Kolita was not the petitioner.
Different case.
How is it connected? Same property, same guest house. The earlier case was a different case. I think that electrocution, or what was it? Okay, Liz, let it be before any other, this before any other bench without. Hold on. Yes,
Your Lordship, for respondent number 4, this is the first appearance. We received instructions yesterday.
okay, you file affidavit, madam?
Yes.
Okay, what about the other respondents? Have you received the instructions? Okay, what is your name? Heard Sri B.B. Kakoti Learned Counsel for the petitioners. But have also heard Sri H. Sharma, Learned State Counsel. Miss, you're there, Madam Fukan, no? And Miss G. Hazarika, Learned Standing Counsel, Revenue Department. What is your name, madam? Miss A Bhuya is present for the response number 4. Full stop para. On a prayer made by the learned counsel for the respondents, 4 weeks time is granted to file affidavit in opposition.
Kindly record this area on behalf of NDAS, because I'm yet to file my
Okay, A Bhuya on behalf of
NDAS,
NDAS,
Nishant Das.
on behalf of NDAS, for the response number 4. 4. We give you a date, file it before that. Today is 26th. We'll have it on 25th of March. You're seeking time. Yes, AGCL. You need some time. Why do you need time? Huh? Okay, we'll have it when? Next week, madam?
Lordship, we have also received the instructions.
Okay. On a request made on behalf of the petitioner, matter is adjourned to be listed. When? On 9th of March.
Lordship.
Until 13. What is the matter, Mr.?
Lordship, we have the, excuse my voice.
Here for whom?
We have also the
Cake war, okay. You've got the instructions.
instructions. This said that this primary prayer, which challenges the minutes of the meeting, which has been written as 26/12/2024, that actually happens to be 27/12/2024, but inadvertently an error record, it was written as 26/12. And furthermore.
No, that doesn't make any difference to his claim. He's saying that it has to be evenly represented. There are the population pattern is such that there has to be more percentage of the community of in which the petitioner belong. That is your prayer.
Sir, the petitioners have participated and there was taken decision that two of the wards will be reserved for ST.
You file your affidavit. Madam, your affidavit will not be required perhaps. Who will file affidavit? Who's this? You okay. You're for the representative department, Panchayat.
Yes.
Okay. Heard Sri SJ Learned Counsel for the petitioner. Full stop. Also heard your name?
A.K. Ghosh.
Also heard Sri A.K. Ghosh Learned Counsel appearing on instruction of Sri K. Kaur, the Learned Standing Counsel for the PNRD. Oh, he's a Learned Additional AG. Full stop. Also heard, no, a semicolon given. Miss Casta for the State Election Commission. Mr. Das, you are there on record? Okay, and that's about it. And that's okay. AEG is there, not required then. Okay. On the prayer made on behalf of the respondents, matter is adjourned by 4 weeks to enable filing of affidavit in opposition. List on 23rd of March. Then 14 to 17. Hmm? What is the matter, Mr. Hussain? 2012.
The same order was set aside by the. Thereafter, in the year 2002, the private respondent had an and on 7 of 2025, reform the 2018 order and included one of the 4 land projects. Whereas the private respondent had some investment of only 1 lakh under 30 years. But in review, the review board has included one more that.
Yes, Mr. Sharma, you're for whom?
What's
Private-
it? I'm for
private respondent.
Respondent number 7 to 12, what's it?
So when can we have this matter?
What's it? Maybe on, what's it, 12, what's it? 12 March, what's it?
12 March, okay. Letter number 12. Hmm. 12 March of 12. Heard Sri M. Islam, Learned Counsel for the petitioner. Oh, M. Hussain, Learned Counsel petitioners. Also heard Sri H. Sharma, Learned State Counsel, Ms. G. Hazarika, Learned Standing Counsel Revenue, and Sri B.P. Sharma,
What's it?
Learned Counsel for the respondent numbers
7 to 12. what's it?
7 to 12. Full stop. Yeah, the contesting respondents have filed affidavit which has been responded to, which has been replied by the petitioner. Full stop. The parties are in agreement. The learned counsel for the parties are in agreement that the matter can be taken up for disposal at the admission stage. Records will be required. Revenue Board,
I think no, actually, the award is in the petition itself.
okay. On request, list for admission hearing on 26th of March, 26th March, Thursday. Interim order passed earlier to continue till the next date of listing. 26th March.
18, item 18.
Or the one on the last day, okay. Okay, they did it. Item number 18. Yes, forest is there.
And yes.
No, forest was not required to file an affidavit. They had placed the Abdul Khalik Supreme Court judgment. Mr. Sigdar was supposed to.
Forest land, forest. Or ecological balance and environmental protection of the resources is significant. But during this case, the different protection is that they are because never was forest land and their years have been have been allegedly by applying the notifications by 296.
Mr. Sigdar, this aspect can also be looked into by the committee. Committee has been approved by the Honorable Supreme Court. If you contend that this is not forest land, it will be excluded from the purview of eviction from forest land.
We are challenging the act. We are also challenging the after 52 years, they are applying this notification, doing that this land also, this village is also included. How that can be applied after? And then
It's not an application of a notification. Notification was always long existing. You are in occupation of forest land in violation of a notification from 73. And how do you challenge the 73 notification in the year 2026? Explain your conduct.
they are not implemented, never implemented that this type of notification has been issued, their village has been covered.
Are you required to be intimated of a notification?
They have implemented.
A notification is available in the public domain. How can you say that every notification has to be given to you? It's in public domain. It's not a notice that needs to be given to you that you need to evict. Make out a case. You file before the committee. Now after Abdul Khalek, Supreme Court will not have any scope. You file your application before the committee. Committee will decide. Abdul Khalek what decision. Where is Forest? Mr. Gogoi. Aditi Barham. We'll have your matter on Monday next. Monday next. Okay. But there is no scope, Mr. Sigdar. No, you have a case to make out. You
But our contention will be recorded.
no, we'll record your content and will give you liberty. In fact, this Honorable Supreme Court has said the committee has to look into all the grievances. If you make out a case that it are not covered by forest land, but now you cannot challenge a notification by which that area is already under forest. It's not a new notification. That something has now been included. These matters have all been taken into account by the Honorable Supreme Court. If you read the judgment, if you have done, everything has been taken into consideration. In fact, Supreme Court has said we are not expressing anything on merits. It will be the committee which will take a call. Committee will decide. But the importance of maintaining the ecology, as you have rightly pointed out, that is the first paragraph. Okay, Hertz 3 urge the learned counsel for the petitioners. Put stop. Though the state is represented, comma, the learned standing counsel of the forest department is not present. Put stop. On the last occasion, comma, the learned standing counsel has placed before this court the recent judgment of the Honorable Supreme Court dated 10/2/2026, passed in the case of Abdul Khalek and others versus the state of Assam and others, reported in INSC to Diriba. Para, in the interest of justice, the consideration of this matter is deferred till Monday next. Monday to oh. Rest, perhaps matters we'll have to give a date, unless it's very urgent date, otherwise court master will give dates. Is there any urgent matter or interim order is still today? Which one? Interim is there. 19. What is the matter about? Okay. We'll have it on when?
They are supposed to join Saturday report, madam.
No, we'll consider it on 6th of March. Paucity of time, 6th of March, interim order continued. After 10th, then 11th of March. Huh? No, only interim, whether is interim, item number? Is it listed today? Item 20, okay, same date, interim order. Mr. Mahanta, Mr. Court Master will give a date.
Just a series of review petitions.
Yes,
Maybe fixed.
just a minute, yes.
Series of review petitions
Yes,
needs to be heard. So,
Court Master will give a date of your convenience. Okay, yes, Mr. Day. We'll give a date as per your convenience. Okay. Mr. Roy? When next week, next Thursday. Okay.